Good evening and welcome to the monthly meeting of the Arlington Board of Zoning Appeals, also known as the BZA. I'm Judy Freshman, Chairman of the Board. The board's made up of 5 citizens appointed by the Circuit Court. In addition to myself, we have Charles Smith, Inta Amalis, Paul Melnick, and Peter Owen. Also present is the professional staff, including Stephen Rissy, Coordinator for the BZA, Arla Vaughn, Zoning Administrator, Blake Bowen, Assistant to the Zoning Administrator, and Simon Keynes, Administrative Technician. We thank you for being here and extend a warm welcome. To avoid disruptions, we ask that you please turn your cell phones or pagers off or put them in silent mode. On the front table, you will find copies of the staff report for each case before us this evening. I recommend that if you've not yet seen the report for your case, that you get a copy and review it before your case is called. The board's powers are prescribed in the Code of Virginia and are set out in further detail in the county's zoning ordinance adopted by the county board. The Board of Zoning Appeals does not have the power to rezone property or to amend the regulations set forth in the ordinance. That authority rests with this county board. This board does have the authority to do 3 things. We can approve use permits that allow modifications of placement requirements for structures on 1- and 2-family lots where there's no option in the zoning ordinance to allow such modifications. We can grant variances from the specific requirements of the zoning ordinance, and we can decide appeals of decisions of the zoning administrator. When approving use permits, the Board of Zoning Appeals may impose conditions that it deems necessary in the public interest, including limiting the duration of the use permit. In order to approve a use permit, the law requires that the board find that the proposal meets conditions and that the use permit will not adversely affect the health or safety of persons residing in the neighborhood, will not be detrimental to the public welfare or injurious to property or improvements in the neighborhood, and will not be in conflict with the purposes of the master plans and land use and zoning related policies of the county. To do this, the BZA shall consider whether the modification will promote compatibility of development with the surrounding neighborhood because the structure's overall footprint, size, and placement are similar to the structures on the properties surrounding the lot in question, and whether the modification will help preserve natural landform, historic features, and/or significant trees and foliage. When granting variances, the burden of proof is on the applicant to prove by a preponderance of the evidence that it meets the following criteria. The strict application of the terms of the ordinance would unreasonably restrict the utilization of the property, or granting the variance would alleviate a hardship due to a physical condition relating to the property or improvements thereon, and the property for which the variance is being requested was acquired in good faith and any hardship was not created by the applicant, that the variance granted will not be of substantial detriment to adjacent property and nearby properties in the proximity of the geographic area, that the condition or situation of the property concerned is not of so general or recurring in nature as to make reasonably practicable the adoption of an amendment to the ordinance, that granting the variance will not result in a use that is not otherwise permitted on the property or change the zoning classification of the property, that the relief or remedy obtained through the variance is not available through a special exception process as provided for under the zoning and/or subdivision ordinance. When deciding appeals of the zoning administrator, the board must use its judgment to determine if the administrator was correct. This evening, cases will be called and a brief report and recommendation will be given. Following that, board members will ask any questions of the staff they may have. Next, applicants or their representative will be given an opportunity to make comments to support the application or appeal. If they choose to make a comment, they must come forward to the podium so their comments can be recorded for the record. Next, all speakers for the items will be called. Speakers must fill out a speaker slip, which is available on the table in the front of the room. After we hear from speakers for and against the proposal, the board may permit the applicant a brief opportunity to clarify any points. The board may ask questions of any speakers, but does not permit and will not condone any cross-examination or direct questioning by others. We've deemed the following time limits for speakers to be sufficient: 20 minutes for appellants in appeals, 5 minutes for applicants for use permits and variances. For use permits and variances, we have deemed 3 minutes for representatives of organizations and 2 minutes for individuals as sufficient. After the board has gathered all the information they need and discussed the case, it will decide the matter by voting on a motion duly made and seconded. A majority is needed to approve any motion. Any appeal from the decision of this board must be made to the circuit court in accordance with state law. After your case of interest is heard, you're welcome to stay for the balance of the session or leave at your convenience. Again, thank you for being here this evening. Please call the first case.
Case number V-11099-16-VA-3 is a variance request by Elena Keith, the owner, to permit a setback of 4.5 feet to the wall instead of 10 feet as required, and 2.9 feet to the eave instead of 6 feet as required from the left side property line, to permit an aggregate side yard of 12.5 feet instead of 18 feet as required, and to permit a setback of 18.2 feet to the rear property line instead of 21 feet as required from a rear deck, regarding a new 3-story single-family dwelling in the RA818 zoning district, premise known as 2216 North Culpeper Street. Staff recommends that the board adopt the proposed resolution deferring the subject variance request to the November 15th, 2017 Board of Zoning Appeals hearing. And please note that there is supplemental material for this case that came in after the application packet was printed.
Questions for staff?
I have a question. This is being deferred with the agreement of the applicant?
Correct.
And it's because they're going to have a meeting with the community in October. That's, I think, what it said in here.
I believe the Civic Association has asked for them to have that meeting. We're deferring it because we're still working on getting the drawings clear so we know exactly what we're applying for.
Okay, so it's not to work around the community meeting on the 25th, because I wondered if, obviously, the community had some reaction to it.
It certainly affords the applicant that opportunity.
Right, but if the community had some wish to make changes or anything, that wouldn't be ready for the November hearing.
Correct.
So we might be looking for another deferral if
Correct.
that's the way it played out. Okay. That's my question.
Started in 16. Mr. Owen.
I do think that it would be worth, since I don't see the applicant's representative here tonight, communicating to the applicant that I think the last time we talked about this, we explicitly had the expectation that meetings between the community and the applicant would occur. And so it shouldn't be hard for the applicant's representative to imagine our reaction to that meeting not occurring after all this time.
I will note that they did go to a meeting between your last time you've heard it and now, actually.
Okay.
The Civic Association has asked that they come back.
I see.
Because they didn't have plans.
Got it. Speaking for myself, I think it's probably a good idea for the applicant to go to that meeting and not come back to us until they've worked it all out as much as they feel they can with the neighborhood. So you could pass that word back.
I will convey that to the applicant and their agent.
The second is that you mentioned that we had a letter or an email that was sent to us for this item. Am I correct in thinking that that'll just be included in the record whenever we next have this up for consideration?
Correct.
Great, thanks.
If you're working on plans and there's supposed to be another community meeting, does it make sense to defer to November rather than December? I mean, December rather than November?
It's at your discretion, the length of deferral.
Well, it just strikes me that we've had so many serial deferrals, and this is one of them, that if there are a couple of outstanding issues and there are advertisement deadlines and other things, that I would prefer at least to go to December and allow those actually to happen so that we maybe can actually hear this in December.
Madam Chair.
Mr. Owen.
In the case V-11099-16-VA-3, I move that the Board of Zoning Appeals defer this item to the December 2017 BZA meeting.
Second.
Moved by Mr. Owen, seconded by Mr. Smith to defer to December. All those in favor?
Aye.
Aye. Thank you. Next case, please.
Yes, case number V-12238-17-VA-1 is a variance request by Douglas Marshall, the owner, to permit a main building footprint of 35.7% and a total lot coverage of 47.9% regarding a new two-story addition with attached garage in the R8 zoning district on the premise known as 6100 31st Street North. Staff recommends that the board adopt the proposed motion deferring the subject variance request to the December 20th, 2017 Board of Zoning Appeals hearing.
Are one of these two, have we not already deferred one of these two
Correct.
on Monday?
On Monday, we deferred the use permit, I think I just read you the variance, which we did.
It was my understanding we deferred the variance. The use permit wasn't before us on Monday.
I believe you're correct.
Okay.
I will move on to the next case, since we have already deferred that item.
So we can just toss it.
Yeah.
Thank you. Proceed.
Case number V-12238-17-UP-1 is a use permit request by Douglas Marshall, the owner, to permit a setback of 23.2 feet to the wall from the North Ohio Street right-of-way instead of 25 feet as required, and to modify a previous variance approval that permitted a setback of 16 feet to the North 31st Street right-of-way and 10.8 feet to the North Ohio Street right-of-way for a front porch regarding a new two-story addition with attached garage and enclosed front porch in the R8 zoning district on the premise known as 6100 31st Street North. Staff recommends that the board adopt the proposed motion deferring the subject use permit request to the December 20th, 2017 Board of Zoning Appeals hearing.
Madam Chair,
Mr. Smith.
I move that the Board of Zoning Appeals defer the use permit application in V-11238-17-UP1 to the December meeting of the Board of Zoning Appeals.
Second.
Moved by Mr. Smith, seconded by Ms. Malice to defer this application to the December BZA meeting. All those in favor?
Aye.
Aye. Thank you. Next case, please.
Case number V-11288-17-UP-1 is a use permit request by Andrew J. Monaco and Patrick N. Forrest, the owners, to permit a right side setback of 7.3 feet to the wall of the rear addition instead of 10 feet to the wall as required, and to permit a left side setback of 7.1 feet to the wall instead of 8 feet as required, and to permit an aggregate side setback of 11 feet instead of 18 feet as required, and to permit a rear setback of 21.7 feet to the wall of the addition, 19.7 feet to the eave instead of 25 feet to the wall, 21 feet to the eave as required from the rear property line, regarding a two-story rear addition in the R5 zoning district on the premise known as 1035 19th Street South. Staff recommends that the board adopt a resolution granting the subject use permit request with conditions. I would like to note, however, that the applicant has pointed out that the proposed resolution for this case contains some language from the last time it was heard with some different numbers. So if you are going to approve a resolution, I would recommend reading off the actual request for this meeting.
Okay, thank you. Questions for the staff, please? Applicant, please.
Madam Chair,
Sorry, Mr. Owen.
I was a little confused by what Mr. Rissy just said. So if we're inclined to approve what staff is recommending approval of, what should we do?
Just read off the requested use permit dimensions as opposed to just using the dimensions that are included with the proposed resolution currently in the staff report.
The proposed resolution on page 5 does not have the correct dimensions.
Correct. It has the dimensions from the last time the case was heard.
Okay, thank you.
So use the information in the subject line?
Correct.
Okay, thank you. Applicant, sorry.
That's right. Hi, I'm Andrew Monaco. I'm the applicant for this project. This is deferred from August, and I apologize I wasn't here. I had a long-standing obligation that I was at, but I had a representative here. The previous proposal was to go straight back into the rear yard. going 15 feet over the 25 required setback. And so we've basically rotated the addition. Now we're minimally going over the back, 4.3 feet, encroaching into the rear yard setback, but now we are going over a little bit more on the side yard setback. The reason that the footprint didn't change was because it was, I don't know if this was fully explained the first time, but it's dictated by the main floor plan. Reason being kind of a modest bedroom, bathroom in the back corner for aging parents, communal living space for our family, and then if they do hopefully move in with us, then it would be a good size or a reasonable family room, and then stairs into the backyard, and that's what is on the main floor, and that kind of dictates the second floor and first floor. The original design attempted to preserve the look of the house from the street with the nice front porch. We really enjoy the front porch. It's our goal to keep that, the historic charm of the original house, and we like the character of our eclectic neighborhood. We would rather build a nice, respectful addition on the back of the house than do like a lot of people are doing, or the developers are doing in our neighborhood, which are tearing it down and building a garage-fronted and kind of by right huge house on their property. That being said, we appreciate staff's work and research that shows our proposal is comparable to other projects that have and use permits that have been approved, and we appreciate the recommendation for approval, and we look forward to the board's decision. Thank you, and happy to answer any questions.
Any questions for the applicant?
Are there any other submissions from neighbors beyond what we have in the packet?
Yes, we have a note that's in your supplemental package and a response from the applicant as well.
Okay, but these are, what I have is Civic Association
And the response?
and the Civic Association response.
No, the applicant's response.
But no neighbor responses. Because there's a couple of neighbors that have not, I don't see input for.
Correct. We have nothing from individuals.
Well, are there speakers on this?
No.
There were, you have the neighbor letters, the original neighbors, the surrounding neighbor letters, right?
There's a couple. You've got immediately behind you and then on the side, but not the sort of the catty ones in the back.
Those are both rentals. I'm not sure of the owners, but they are both rentals.
And then the one in front. Okay, thank you.
Other questions for the applicant? Blake, no speakers, right? Thank you. Okay.
May I ask another question? So the Civic Association has or has not weighed in?
The Civic Association, yes, they wrote a letter last night that I received at like 8 o'clock. That should be included in that.
And they're not officially weighing in, or are they? I've got one from
Arthur Fox.
Arthur, yes, but it's apparently not the whole board.
But that's not, I'm gathering that's not an official, or is that the official?
I think it's,
Well,
it's disputed.
Right, it's disputed.
Here?
Correct. So I've been working with their secretary on their board
Right.
for a couple months now. I had a meeting with them. I offered to go to their board meetings. I offered to go to the community meetings, and they said that was not needed. That they deferred until the staff report. And so when the staff report came out, I sent that to them, and I still didn't get a response until the letter that was penned last night. And then I got a letter or an email that's included from the secretary saying that that was written solely by the president. Not all the board had even had a chance to comment on it or review it. So,
Okay.
I mean, I don't know what else could have been done.
Thanks. Other questions?
Madam Chair, any other speakers? I'm prepared to make a motion.
Mr. Melner?
Okay, so in this case, I move that the Arlington Board of Zoning Appeals approves this use permit request to permit I'll go ahead and read it like you were saying.
Thank you.
To permit a right side setback of 7.3 feet to the wall of the rear addition instead of 10 feet to the wall as required, and to permit a left side setback of 7.1 feet to the wall instead of 8 feet as required, and to permit an aggregate side setback of 11 feet instead of 18 feet as required, and to permit a rear setback of 21.7 feet to the wall of the addition, in parentheses, 19.7 feet to the eave, end parentheses, instead of 25 feet to the wall, okay, parentheses again, 21 feet to the eave, end parentheses, as required from the rear property line regarding a two-story rear addition, R5 zoning district, premises known as 1035 19th Street South, Addison Heights, in parentheses.
Second.
It's moved by
Sorry.
Mr. Melnick and seconded by Mr. Owen for approval as detailed.
Madam Chair,
Mr. Owen.
my understanding of the motion is that this includes all the conditions that are listed in the staff report on page 5. That is the resolution on page 5, except that the first whereas is adjusted to be in the manner that Mr. Melnick outlined.
Yes,
Yeah,
that's my understanding.
yeah, I can clarify that, the rest of the standard resolution applies, with the addition of my clarification of the description.
Everyone understands? Yes. Okay. Moved and seconded. All those in favor? Aye. Thank you.
Thank you. Thank you for your time.
You're welcome. Next case, please.
Case number V-11293-17-VA-2 is a variance request by the Army-Navy Country Club, the owners, to permit the installation of a protective net and poles with a height range not to exceed 55 feet instead of 35 feet is required regarding a new protective net and poles bordering 18th Street South on an existing driving range in the R6 zoning district premise known as 1700 Army-Navy Drive. Staff recommends that the board adopt the attached proposed resolution granting the variance with conditions. An alternative resolution has been provided should the BZA wish to deny the variance.
Questions for staff? Applicant?
Apologies. Good evening, everyone. It's nice to be back in front of you after 2 months.
Would you state your name, please?
Oh, yes. Nicholas Cummings on behalf of Army-Navy Country Club, and I'm with the law firm of Walsh Colucci. We believe we explored the option that was the reason for the deferral, which was a different process through a use permit amendment or something else along those lines. Obviously, that process is not deemed appropriate by staff, and we accept that, and so we're going forward with this variance. I'll reiterate very, very briefly some of the justification that we went through last time, but the real crux of this request was that there is a problem, not an overwhelming problem, not a necessarily extremely dangerous problem or anything, but an issue that we wanted to proactively solve for the benefit of the neighbors. I just learned that there's a neighbor here tonight who I believe signed one of the letters in the file, and so the club really wanted to go out and try to fix this proactively before anything more than maybe just a broken windshield occurred. I feel strongly that we meet the technical requirements of a variance, and I think that was set forth pretty clearly in the staff report as well, recommending approval. So if there are any questions, I'm here to answer them.
Questions? Mr. Cummings?
Please.
Staff, but then you can weigh in. I just wanted to clarify, on page 4 of the staff report, where there's a discussion of what the county board versus the BZA can do, in the second to the last sentence, it says the Board of Zoning Appeals has the authority to approve use permits that modify the placement of structures, not height, in subject zoning districts.
You have to use a variance to modify the height, not a use permit.
Oh, that's the distinction that's being made there.
And this is a variance.
This is a variance, okay. And because the board, so it must be done by variance, it cannot be done by use permit, and that's why the county board cannot do it.
Right.
Madam Chair.
Mr. Owen?
Can I ask the applicant, how large is the property?
I'd have to refer, it is a number of acres, obviously, but I believe it's going to be in our statement or in the staff report.
253.6.
253 acres,
0.6 acres.
18 square miles. And has the driving range, how long has the driving range been in this exact configuration?
So that was a matter of discussion at the last hearing, and I checked up again with the club, and based on personal memory, because there's no real record that we know of that tells us how long it's been in that location, at least since 1959 or so, when Mr. Walsh remembers hitting on it. 1960. This is the neighbor, but according to the club, it was at least that old.
I see. Okay. And so I have a question for staff, if that's okay.
Keep going.
One of my questions is in the staff report, there's a discussion in response to the question, criteria number 3 on the page 3 of the staff report. So the question, we're required to consider if the condition or situation of the property is not so general or recurring as to make it reasonably practicable to formulate a regulation which can be adopted as an amendment to the ordinance. And my hope after the last meeting was that staff would examine the feasibility of formulating a regulation by the county board to address this situation as a more general level. But the staff report analysis seems to have been limited to the question of whether or not a regulation already exists that allows the county board to grant a use permit or other specific relief. So does staff have any view about how reasonable and practicable it would be to formulate a regulation for fencing around athletic facilities in our zones?
I don't know that we have an opinion about it. That would be a policy decision that requires work by other departments, other staff members. It requires resources. It's got to be vetted by the board, put on a work plan. So there's a process for that to happen. It's certainly possible.
So the other half of that question is whether this situation is or is not so general as to like if this is the only time it would ever happen, then it might not be worth it, but if this might happen multiple times, then maybe it would be worth it. That's the presumption that's in the statutory criteria. And so the response to that part of the question is this property is one of the largest open space areas in Arlington County. Due to the size of this property, variations in topography are evident. Staffed, and then the rest of it answers the second part of the question. I'm not sure why this being a large open space or that it has evident variations in topography relates to its uniqueness from the standpoint of fencing for athletic facilities.
I think it's more that a land use of this size is not something that's generally occurring. So I don't know offhand how many driving ranges or golf courses we have, but it's I think it alludes to the fact that this type of use is not something that we have in great number. And so the idea that we're going to be asked this question again by all the numerous other driving ranges and golf courses in the county would be rare.
Got it. So you were presuming in giving that answer that this situation was limited to golf uses and not, for example, to other sports uses.
Yeah, I mean, I'm thinking about the height of something that's going to...
A soccer field may not need 55-foot netting.
Right.
Routine for baseball fields, though, to have netting at least that high.
Yeah.
Well, that's also my view, but now that I understand the basis of staff's recommendation, I appreciate that. So that helps me understand the discussion. And I think So could I ask the applicant, are you asserting that there is a physical condition relating to the property or improvements that existed prior to the date of the ordinance that creates a hardship?
So I think there were two prongs, really. Obviously, there's the first criteria, which is that the strict application of the zoning ordinance would unreasonably restrict the use of the property. And I think that's the first and possibly the stronger, although I think they're made in the alternative argument, which is that strict application here with a 35-foot, the rule isn't really even necessarily made for netting, but a structure to guard the sides of this driving range as people are utilizing it, which is obviously an approved use on this property, unreasonably restricts that use. In the alternative, of course, we have made the argument that there are topographical issues throughout the site which make it difficult to, A, place the netting, but B, locate the driving range anywhere on the property. It's going to have similar issues with the ability of the height of the netting to protect anyone who's bordering the driving range.
Other questions?
Madam Chair, I have a question of staff. Is the description of the board's authority to grant a variance for height limited to 55 feet?
That's an interesting question. I don't know. I don't want to speak out of turn. I don't know that there's a absolute. I don't know that there's an absolute there.
Okay.
Yeah.
I wasn't seeing one, so
Yeah.
So if an applicant comes in and wants netting 70 feet,
They've got to make a case for it.
case for it, okay.
Madam Chair, just for staff, the 55 you hesitated about because that's a common number used elsewhere?
It happens to be the same number, I believe, that's permitted for the main building. The one allowance for a property of a certain size.
And could the board, BZA, make a variance, grant a variance to exceed a 55-foot building height?
No, because that that authority is explicitly listed as something that can be sought by use permit from the county board.
Wait. I'm not sure.
Full circle here.
So I guess the question is, if someone came in
Saying if you
and
wanted to
asked for an
exceed 55.
80-foot
Sorry.
net,
Okay.
could we grant that by variance?
Sorry. Yes. Now, per the change, yes. Per the 2015,
Because it might be reasonable.
I suppose someone could make that argument.
Right.
Yes.
Mr. Melnick.
I have a question of the applicant. I have a question about the 55 feet that we're talking about. Do you know if that's like an industry standard with driving ranges? Like, how is that number? How has that come about? Because I know the other netting's 55. Do you know how 55 was picked here?
I know for a fact that it's what we did for the other half of the range, and it's been so effective there that it may simply be that we were requesting to match that height because it's been effective on the other side.
Okay. All right, thanks.
We have two speakers. David Nichols.
Good evening, everyone. Thank you for letting me be here to discuss it. I own the second and third house from the entrance of the country club. So for years, I was born in Arlington, and I hope to die in Arlington. I love Arlington County. Everything's great. For years, the country club was a potato field when I was born. So I saw them construct it. I was a child, of course, but as it grew and they built the first one, that driving range has been in the same spot that it is today. It was modified some because in the old days, they didn't have those hills or that the netting that you see now, and the balls would just sort of just fly right over the fence and strike the houses. I've replaced probably 5 windows in my house over the years and about 4 or 5 car windshields and back windows. And I've been struck by a couple of golf balls that would just sort of fly over the fence. One of the general managers from the country club was talking to me in my driveway, and he was struck one time. So, I mean, because, of course, when they hit, you don't know where the ball is actually going. So the first netting that they put up was pretty good, and it deterred some of it, but it wasn't as high as you come into the entrance of the country club. So as you got down range, it sort of blocked it. But when you initially strike the ball and it goes up, that's where you're going to find where the problem is. So it was skimming over the net that you see there and coming directly toward my house. We have a playground on the back half of my place, so of course the kids were being, sometimes they have to dodge also. And the country club has been pretty good to us over the years, as far as being neighbors. Unfortunately, the crack epidemic was in Arlington County and back during the old days, and the country club was generous when it came to replacing people's car windows and stuff like that because of the balls hitting them. Some people took advantage of that. The users, they would pick up a golf ball, go up there, say, hey, my window's been broke out by the golf ball. Back then, the country club would pay either in cash or write you a check. So it just became, they really got a raw deal out of the deal. And they paid thousands of dollars over the years to neighbors they've sort of moved away and died off over the years. But back when it started, that was a field day. The last expense was about 3 years ago when a new neighbor who moved there said a golf ball struck her Mercedes, dented the trunk, and slid across the hood. So American Service Center couldn't match the paint, so she got a $3,100 paint job out of it. So after that, that's when they did it, what they had to do. But anyway, thank you for I didn't know the time limit, but thanks for everything. Y'all take care.
Thank you, Mr. Nichols.
Madam Chair,
Mr. Owen.
I have a question for Mr.
Nichols.
Nichols? Yes, thank you, sir. Did you say that you remember back before the driving range was put in that spot?
Well, when I was born, let's see, as a child, I seen them working on it. And then once it was constructed, yes, I mean, I actually worked over there at one time also picking up golf balls.
What was there before there was a driving range?
Potato field.
Okay. And you think that it changed from potato field to driving range sometime around 1960?
A little before.
Okay.
Yeah.
Could it have been before 1950?
That I'm not sure of.
But
I'm older than I look. I mean, thank you.
So it might matter a lot whether or not it was there before or after 1950. So that's why I ask. Is there anything about your recollection, how old you were at some time when you remember it being a potato field that would help you recall more specifically when it was built?
No, I can't really think right offhand.
Okay.
And of course, being excited, being up here, that throws things off too. So I don't want to mislead you with the wrong answer.
Okay. All right. Well, thank you. I appreciate that. I appreciate your yeah.
Ms. Malice.
Was all of South Arlington a potato field? Because I was told our neighborhood in South Arlington was also a potato field.
It was kind of sectioned off. My family moved up here in the 40s and 50s, so we constructed the houses that we're in today. But that was a potato field, and then someone purchased it, and they leveled it, and then it became the country club. So it's possible.
Thank you.
Thank you.
Thanks.
Karen Nichols.
Good evening. I'm Karen Nichols. I reside on South 18th Street, just outside of Army-Navy Country Club. And to echo what Mr. Nichols has said, we have been there several years, and there have been golf balls that have come across the current netting and have broken car windows and windows in our homes. So we have submitted letters in agreeance and urging the board to approve the raising of the netting to protect our homes and along with our property and those of our other neighbors also. Thank you.
Thank you. That's the last speaker.
Madam Chair.
Mr. Owen.
I want to thank the Nichols for coming to testify. I certainly, if I were in their position, I would find the situation intolerable, and I would demand that my government work with the property owner to figure out a way to protect me better. The question that I feel as a member of the Board of Zoning Appeals is, am I the proper government official to fix the problem? And I feel like, based on state law, my answer is no. That I do not think that this is the situation that the legislature permits us or wants us to, as a BZA, to fix the problem, and that as the state government has set forth, that this is a condition or situation that is general or recurring enough to make it reasonably practicable to formulate a regulation which can be adopted as an amendment to an ordinance. I don't think that, I believe, this is R5 or R6? This is R6. We have a lot of R6 property. We have a lot of R6 property in Arlington that is used for athletic purposes, which includes in the backyards of single-family homes where lacrosse nets and basketball courts and all sorts of other things happen, not to mention, as my colleague mentioned a moment ago, baseball fields. There are lots and lots and lots of sports facilities in R6 zones where it might seem reasonable, if the neighbors don't object to the sports facility, that they might say, oh, well, why don't we just put a super tall net up that would violate the zoning? And I do not think it is a good idea for all those people to come to the Board of Zoning Appeals for case-by-case determinations. Or at least I would want to know that the county board had, weighed in on that. Because 55-foot tall nets or 80-foot tall nets to address these kinds of situations, I think, could bother other people and requires political balancing of uses. So I don't think, I certainly don't think that there is a legal hardship here. I think that this is the location where the fences are supposed, where the netting is proposed to be built is basically flat. I agree that it's an extremely large property. To me, that weighs in the other direction, that with 350 acres, that there might be a better place to locate a driving range than the one peninsula of their parcel that is surrounded on three sides by single-family homes, and that there might be other parcels that might be better suited to a driving range. But I think, or to flip it around in the other direction, so that people are hitting the balls towards the middle of their property as opposed to towards the edge of their property. And to my mind, that might make tall netting more reasonable. If they had netting that was 100 feet tall, but it was in the middle of a 350-acre parcel where neighbors weren't affected by the netting too, that might seem more reasonable. But I just feel like this is not a correct situation for a zoning variance. This is a situation where a regulation should be adopted to the ordinance that governs sports facility screening.
Other quick comments?
Just to clarify Mr. Owen's argument as to the law, you are not disputing staff's analysis that we have the power to grant this variance?
I am.
You are?
Yep.
Okay. I don't know where that, not being a lawyer and not being able to read the law, I don't know where, and not having the county attorney here, I don't know where that leaves us. Obviously, in terms of solutions, one solution is to move the driving range. That solves the neighbor problem, or reorient it. And the other is to put up the fencing. I mean, those are the two solutions. Obviously, one's easier than the other from the applicant's standpoint, and it's certainly easier for us to grant. I need to reflect on the legal question, because I thought you were suggesting that there was a third, that we have the power, but you thought it was preferable that regulation be used.
The way that the state law defines our power includes within it a question of how reasonable is it for the county board to develop a regulation for this, and how common is it? And so there's judgment calls about that, right? It's different than the judgment calls we're used to making, but we have to examine as a judgment call, in our judgment, or ultimately the circuit court's judgment, is this something that is common or rare? And if it's common, is it something that the county board could easily deal with, or would it be hard for the county board to deal with because each situation would be so unique? And that's the evaluation we need to make in order to find out if we have the power to do it.
Madam Chair.
Mr. Melnick.
I'm of a differing opinion because I hear what Mr. Owen is saying here about backyards and sports and even sporting fields, but I do think this is unique. And I don't know offhand about how high nets would have to be for a baseball field, or people playing lacrosse. But I know, golf especially, the balls do go far and high, probably more than, most other sports. So I'm thinking just on account, of what I know, about golf and, the way golf balls go when you hit them, that this is rather rare because it is rare to have a golf facility in Arlington. And so that's where I'm landing, where I wouldn't consider it to be so general or recurring as to make the reasonably practical to formulated regulation, which can be adopted as an amendment to the ordinance, just because golf facilities are so rare, especially driving ranges. So I'm not convinced at this point, that is an impediment. So I just wanted, just to put that out there.
Thank you. Any other comments?
Madam Chair,
Mr. Smith.
I just find it really difficult to grant a variance for netting because this is purely it's for entertainment. And I think, as Mr. Owen said, there are other places where a driving range could be placed. Then it doesn't have to be configured in this way. And there are driving ranges that are that occupy far less space. But I'm just not comfortable granting a variance for sports netting when you've got 250 plus acres and you could put this facility elsewhere on your property such that it doesn't raise the possibility of errant balls impacting anyone other than those in this athletic facility. And number two, I'm concerned with I don't want to call it shifting rationale, but I guess with uncertainty as to what the level of authority that either the county board or the Board of Zoning Appeals have with respect to granting height variances, or the county board granting a permit for for a structure that's for netting that's greater than 35 feet. So, kind of along with Mr. Owen, I think this is an issue that should be addressed, the issue of height for structures, because we had several months ago, I thought, a difficult case with a cell phone tower. And we have cell phone towers that are varying heights. And we had a history of some towers and steeples, church steeples too. I just think that that the height of structures like athletic netting and like cell phone tower and like cell phone antennas need to be addressed. But putting that aside, I'm just not comfortable. I think that the requirements for granting a variance are not as stringent as they used to be, but they're still more stringent than those for a use permit. And I just don't see how the applicant is being unreasonably restricted in the use of their property by the denial of a variance.
Madam Chair.
Mr. Melnick.
Also, something that I think is important to mention is the fact that, in netting, the 55 feet was granted September 16th of 2015, and it was a variance request, and so there's actually precedent, case precedent, for us doing that. And I understand, if, I'd ask staff, I'm unsure of precedental value, but it seems to me that it's an identical case. There we had balls going into residences, I believe, and here we have them going to residences, also cars. But would you like to speak to that?
Madam Chair, I'm sorry. I'm sorry to interrupt you.
Okay.
But before you ask the applicant, I would be interested in having a colloquy with you if the chairman's okay with that.
Well, why don't you let him finish first?
Sorry to interrupt.
Okay. So my point is that, in addition to the reasoning I've already said, is that this very board, has previously granted the 55-foot netting, variance at that time. And I think that should carry some weight, that it's been deliberated and we decided on almost exactly the same facts. That point gave a variance then.
Madam Chair.
Mr. Cumberland.
So before the applicant answers, I actually have a different perspective on that part of the question, on the precedent. So I wasn't on the BZA for that round. So I was forced to listen to the tape and read the materials. And the applicant made a different case at that time. On that side of the property, there's a steep ravine. And they made a case that there was very unusual topography and steep topography, extremely steep topography on that side. And that was the core of the case that they made. And so my impression is that, in fact, although there was a grant of a 55-foot tall fence on that side, that they were making a more classical hardship case that they can't make on this side because the ground on this side is flat and is not a very steep ravine that was the core of their argument last time. So now we have two different perspectives, and thank you for indulging me with that alternate perspective, but now the applicant can address both.
Mr. Mullen.
I do notice that, with you mentioning topography, under the hardship, I do notice in the staff reports that staff noted that there is some variation in topography along this portion that can hinder improvements. And, there's some sections being lower than others. And so here, topography is mentioned, and I wonder if the applicant can address that. If it's such, I hear what you're saying, Mr. Owen, but can you address that about the topography, and does that key in at all to the request?
Sure, and I think we discussed this at in part of the last hearing. We discussed what had happened in the 2014 or 2015 hearing, and we also discussed the topography, its relevance to that prior ruling, and the topography here. Topography is a challenge throughout the site. There are some topographical changes on the 18th Street side, just as there were on the 16th Street side. When we discussed this at the prior hearing, there was a sense among the board that at the prior hearing that the topography was not as big of an issue in justifying it. When I look back through the application and the prior reports and whatnot, the same case that is being made here was largely made there, where the argument is made in the alternative for both unreasonable restriction of the use of the property if the ordinance is strictly applied, and with the topographical challenges on the site. Obviously, we feel strongly that this was setting precedent, but also just from a common sense perspective, the 55-foot net is already there on the other side of the range. It would be effective on this range, on this side of the range. It seems to be, to me, a very, very, very similar situation that is being requested for the exact same reason. And at the end of the day, the crux of this request, of course, is that this is by far the most effective solution here. I can get into briefly whether or not the driving range can be rearranged around the site, and I have a few overhead shots of the course, but as you can imagine, there's 27 holes of golf on this property. It's packed in very closely. It's designed very carefully. To rearrange where the driving range is would require a redesign of the entire course, and I talked to the pro Greg Scott about that today. It would be a very, very expensive endeavor and is not one that is feasible for the club to indulge in to solve this problem.
Other comments or questions? Motion?
I'll make a motion.
Mr. Melnick.
Okay, so see, in case V11293 VA2. I move that the Board of Zoning Appeals adopt the attached proposed resolution granting the variance with the conditions as stated in the resolution.
Is there a second? I will second. Discussion beyond what we've already heard.
You know, what's going to happen is I'm going to end up abstaining, and we're going to have a 2-2 situation here because I'm guessing, possibly not, but I'm concerned about the legal question that's been raised. And I'm very familiar with the case that came before us. I was here, I was very new, and I remember the discussion. We did not have a discussion about the law. Now that we've had a discussion about the law, I feel less certain about what's appropriate here.
And the lawyers on the board are split?
Okay, can I speak, please? Madam Zoning Administrator, is it your opinion that there would be something that might be gained by getting the county attorney to weigh in on this debate? You already have. It was clear to me that if there was actually a zoning change, that was going to be very difficult to achieve and time-consuming. But it's your position that, from the legal standpoint,
The BZA has the power to grant it.
okay. Thank you. That's clear to me. Thank you. Other comments before we have a vote,
Madam Chair.
Mr. Allen?
And that analysis was premised on a zoning change that would apply to golf courses and not to other athletic facilities generally, or athletic uses generally in our areas.
The analysis was based on what regulations currently exist in the zoning ordinance, what provisions there are for county board use permits that might apply, and the Code of Virginia, and how that authorizes or grants the BZA its powers.
My reading of the staff reports conveying of the county attorney's comments is that they presumed that the county board would never create these regulations. And if the county board would never create these regulations, then perhaps we would have the power to do it. But I'm not sure I share that presumption. I think that if, for example, we deny this variance, I expect that the county board would then start to create regulations. I don't think they would just leave the situation as it is. That would be my personal guess.
Or the applicant would challenge it in court.
If they lose, if we get backed up by the circuit court, then eventually that's what I think the county board would do, and they wouldn't throw up their hands and say, we're helpless. We can't possibly solve this problem with the resources we have available, and it's only one situation that we'll ever face. I don't think that would be their reaction.
So, and Madam Chair, just to kind of respond to Ms. Malice's concern, we had, in the packet that we had a couple of months ago, there was a lot of historic information. And I recall seeing a series of amendments to the use permit which created the golf course, or which was passed, which facilitated. The golf course had predated the zoning ordinance, but the use permit then was granted afterwards to bring it into, to give it a legal status. And subsequent to that, there had been numerous instances where the golf course had gone back to the county board for adjustments to that use permit. And so I don't see why that avenue is foreclosed now. I guess I don't. I read this paragraph that where staff, it says staff, where the applicant's agent and met with staff and discussed whether a county board use permit amendment is an appropriate mechanism for the approval of the height of the protective netting. Staff conferred with county legal staff and concluded that the correct mechanism for the approval of the height of the protective netting would be a variance from the BZA. It doesn't say that the county board can't do it. It says that it would be correct, but it doesn't say this is the only avenue. I just, given that history, I just don't see how that is foreclosed now. I don't know what's happened in the interim to change that. It's still a creature of a use permit. So I guess that's one of the things. That if it were a house and they wanted a variance for protective netting, I would be very, very, very concerned about it. It's not a house. It's an athletic facility. So I really, I think that, and I really think it militates for going back to the county board with, and if the county board doesn't have the authority, somehow has lost it, I think that then the golf course needs to go to the county board and ask that it create the authority again. But I'm not comfortable. I know the history that 2 years ago when we did discuss, there were some issues with respect to the topography, which aren't in play. And in hindsight, I guess I wasn't really all that comfortable then. But I'm far less comfortable now.
Okay, we have a motion on the floor for approval. Motion made by Mr. Melnick, seconded by Ms. Freshman. All those in favor? Aye. Aye. All those opposed?
Nay.
No. Madam Chair.
It fails 3-2.
Madam Chair,
Mr. Owen.
I move the alternative resolution for denial.
Is there a second?
Well, Madam, I guess I would ask that if we didn't grant the variance, that is the effect of a denial, isn't it?
I don't know.
Do we have to move the alternate?
I think
I don't think so. I mean, once you deny.
then you haven't taken any action. You just made a motion that failed.
Sorry. Yeah. But it was 3-2. You didn't abstain, did you, Ms. Mallon?
We haven't disposed of it. We've had situations before where we deadlocked, and so then it automatically carries over and stuff. So I think we need a disposition.
But we didn't deadlock.
Right, but I think we need to.
We voted 3-2 to deny the variance.
No. The motion was to approve, and it failed.
Okay. I'm sorry. I thought it was a motion to deny.
No.
Yeah, no. What was on the floor was a motion to
Melnick
approve.
moved to approve, and you voted, and you seconded it, and okay. I'm sorry.
Okay.
You ready to second me now?
We won. We did win.
Well, we can win if you second my motion.
I'll second your motion to deny the variance.
All right.
Motion made by Mr. Owen, seconded by Mr. Smith for denial of the variance request. All those in favor?
Aye.
Opposed? No. Thank you. Next case, please.
Next case is case number V-11296-17-UP-1. It's a use permit request by Henry and Yulia Lehman, the owners, to permit a 6-foot-high fence instead of 3 feet within the 25-foot triangle required for vision clearance on the front left corner of the property, and to permit a 6-foot-high fence parallel to the right and left side property lines instead of 4 feet is required within 25 feet of the easement for street purposes adjacent to the South Monroe Street right-of-way, regarding a fence with associated columns in the R5 zoning district on a premise known as 1117 South Monroe Street. Staff recommends that the board adopt the attached resolution granting the use permit with conditions. An alternative resolution is provided should the board wish to deny the use permit request. And I'd also like to note that there is supplemental material for this case that came in after the application was assembled and printed.
Madam Chair.
Thank you. Mr. Owen.
Mr. Rissy, the supplemental material, can you describe the supplemental material that's been presented to us?
We actually have 2 items. The first item is from Mr. Lehman, who says that he believes there are some mistakes made in the report that he would like to have corrected. And there's a second supplement, which is from David Patton of DES, who was asked about the bicycle status of the streets surrounding this area.
Has the second item been given? Do we know if the applicant has a copy of that supplemental?
I do not believe he has received that.
All right, can we arrange to make sure the applicant has that before, as soon as possible? Because I think the applicant's entitled to the information that's presented to us.
Sure, I'm willing to give him one now.
Thank you. So I don't want to multitask staff, but my next question will be, which I'll be happy to repeat, is does staff think that there's a factual dispute about where the lines are drawn? So that's going to be my next question. So my next question, Mr. Rissy, is it appears, based on the letter that we got from the applicant that you just mentioned, that there remains a factual dispute about the location of the 25-foot triangle. Do you agree that there's a factual dispute that remains?
I do not believe there's a factual dispute that remains because I believe the zoning administrator has declared the configuration which was presented in the staff report to be correct and not in error.
You think you're right, but wouldn't you agree that the applicant thinks you're wrong?
I agree that the applicant thinks we're wrong.
Okay, thank you.
Questions for staff?
Okay. All right.
Excuse me.
Yes, yes.
Were there other questions of the staff?
Madam Chair, I just want to be clear that the plat that staff believes is accurate is the got the red marking on it. Highlighting in yellow, but there's also red lines.
It appears as though the plats and all of them are the same. The difference is the annotations on them.
Yeah, the annotations, that's what I'm talking about. Okay, the plats are the same, but they're annotated differently. I guess my question to staff is there, the annotations that are in red, who did those?
I believe Sam is the reviewer who...
Okay, staff here, not the applicant, not...
I'm getting a head nod from the applicant, so maybe he could better answer that than I could.
Oh, I see, you're asking on the applicant's submission, who did the lines? On the
Well,
applicant's-
yeah, this oh, I'm sorry, I thought this was in the packet.
Yeah,
This is what was submitted with this email from Mr. Lehman. Okay, I'm sorry, I thought it was staff, so I'll ask the applicant if he created it.
What staff has shown and what the applicant is showing in his submission.
Okay, let's start with the applicant, please.
Okay. I received the email from Mr. Stephen Rossi. Rissy, the other day, and when I read it, I said, you know, it's not anything near what we talked about here on the 8th floor. It's not what the supervisor said, and it's not what I understood. And I certainly don't agree with what it says about the new property line because I don't know what that means. I have a property plat that shows where my property lines are. I don't know what the new property line means. And I'd like to have that at least answered. Does that mean something that I'm going to lose, or is it just something that's just stated? Okay? That's one thing that I have an issue with. Another thing I have an issue with is the 25-foot setback with the new property line. Because when we were up there getting the permit, that the supervisor put her finger on the paper and said, this is where you measure from. It was clearly where my plat says that it, where I put the fence and built the fence to be at, okay? And we went over this 3 or 4 times, and we were back and forth, but we settled up that the property line that's on the plat is what we use for the 25-foot. Now, if you use this from from what Sam put on, that creates a discrepancy. If we look at the plat that I've provided numerous times, you'll see that it has a little triangle at the corner. You have a clean plat, and I have a clean one over here. And when I bought the property, that's where NV Homes told me that that's the triangle for the 25-foot setback. Now, at the time we were buying the property, we were looking at the plat, because our intentions was always to put an iron fence around this property before it was ever a foundation put in the ground. We already had that idea. And if you'll look at the plat, do we have a clean plat?
They have the submission that you gave me. So they have.
Okay, and you can see it has no markings, but you'll see that little corner with that little mark, and you'll see the little drawing that I did with the red lines. That's from a calibrated caliper, one that I have used for the last 20 years. I do this stuff for a living. I take care of people, and I do lots of stuff with moving buildings and things around. So I'm not unfamiliar with what we're talking about or what we're doing, because we get things that are out of place or not. We don't think it goes there, but it does. Okay, and I think we should, personally, I think my stand is that we should go ahead and just, because it is a see-through fence, and it's over 80% see-through, that it is no hindrance to people's vision, whatever people walking around, because I have asked numerous people on more than one occasion that they come, well, I drive through here and I don't have an issue with it. It looks great. You know, people walking up, and no, I never had any problem walking up here and being blindsided. You can see right through it. You know? So I think we should just leave it alone myself and just, if we need to do something, I got around between $7,000 and $8,000 tied up in just this little corner with a column and all this decorative fencing and all of that, and it's going to cost me a pile of money to change it. Okay? Now, if there's any questions that you guys have for me, I'd be glad to try to answer them. You know.
Go ahead.
Just a quick one. So, in your submission, where you highlighted in red the little corner piece, what does, in your view, that little triangle represent?
That is the edge, corner edge of the 25-foot, okay? The corner edge. If you read this, this is actually the triangle tip.
Okay, but in your view, what does that triangle mean?
That triangle means that that's where the 25-foot requirement might be at or would be at. But there's a column sitting there. We're talking about 7 inches on either side of that column.
Can I just ask, Stephen, I'm presuming that the plats that we've been looking at on the screen are the ones that are in the staff report.
Correct.
So the applicant has given us different versions.
Different way.
Correct.
Right, okay.
And you're talking about that drawing or the other one before that?
Yes.
There are some plats or some drawings and all, but the biggest issue is that when we came over here after our first meeting and all that, we went up to the 8th floor, 8th and 10th floor, and they relayed to us that they had lost the permit. And they told my wife that that's not the only one they lost. Okay? I think that I have the original, all of the original ones to go with that. I'm sorry, That's what we were told.
Okay, we have a speaker. Can we call the speaker and get another opinion? Dawn Massey. And Mr. Lehman, we may, of course, come back to you at some point.
That's okay.
Okay.
I want to try to get this thing resolved.
Well, and the staff is recommending approval, so I'm just saying.
Good evening, Madam Chairperson and the rest of the board. Thank you for having me here. I'm here on behalf of the Pike 3400 Town Board and Community, of which the applicant's home, as we understand, is a part of that and under the same covenants and such. We have had kind of a plethora of input from board meeting, the most recent, of homeowners telling us when they strolling babies in carriages, one of the neighbors driving the car in a regular sedan versus an SUV, and pedestrians are having sight visibility issues with the corner, and I think Mr. Martin just sent you something, showing the limiting of visibility for safety, welfare, and overall health of people who are coming around that corner. There has been one or two very close calls, I understand, and an actual incident. That being said, we would hope that we can work out something to eliminate that safety issue for our community and neighbors. A compromise of some sort. We understand the amount of expense already put by the homeowner, but the greater community safety and welfare is of the utmost concern for our board and our neighbors. Perhaps a lowering of the column. The fence is an open iron fence, but there is a brick column that I believe is 8 foot high. You can't really see through that. Perhaps a lowering of that about 4 feet might, that's a suggestion, or some compromise or eliminating it.
Madam Chair.
Questions for the speaker?
So lowering the column is one option. Were there other options that your board discussed?
Elimination of the column, or pulling back on that corner on an angle, perhaps, rather than it coming so far out to the corner, which, as we understand, does not meet the code zoning ordinances. Okay. It's not in compliance, and the fact that it has a safety issue, I know, is obviously a big concern.
Thank you. We were looking for solutions.
Sure.
Mr. Smith.
Question of this witness. The association has existed for, I assume, at the beginning of this, when this development was occupied.
As I recall, and I wasn't on the board until of just this past month, my recollection as a homeowner attending the first meeting was about summer, if not late summer.
So it's a newly formed homeowners
association? A year ago. Mr. Martin, would you like to speak?
Because this development has been there about 3 or 4 years. Homeowners association is new.
I've been in I can tell you I was one of the first groups, and I'm in my home. It was 2 years this past April. However, I know that the last of the community and the turnover of the HOA to the homeowners was after all the completion and work with the developer. I also know, sir, with due respect, that the application, from what documentation that we were given to read just recently, was that this was put forward through the developer builder prior to the turnover of the homeowner association's handover.
Okay.
So that it was never addressed, to my knowledge, within a homeowner's meeting or materials prior to.
Okay.
Other questions? Mr. Melnick? Microphone.
Yeah, it's not a question. I had a question of staff. I guess we can wait until all the questions are finished.
Any other questions of the speaker? Okay, go ahead.
Thank you.
So what my question is, it looks like I'm questioning the location of this triangle, because it looks like, so I see clearly on the plat, you can see on the right-hand side where we're talking about the street easement, and what appears to be sidewalk and utilities purposes easement, is, so the rule, yes, so the rule just discusses the triangle formed by the street right-of-way. And I didn't know if staff has a copy of the easement in Deed Book 4228 at page 943, or whether that's been referenced, where that actually says street purposes. Because if it doesn't, then it seems like, the line for the triangle is really where it's the existing easement for public street and utilities purposes, which is, the one, closer to the street. So it looks like the applicant is going on one line and the county's going on the other. So I'm wondering if this is somewhere in between.
So generally speaking, if the easement references public street purposes, that is where we measure from. So public utilities, public sidewalk, nothing changes in terms of how we apply setbacks or yard requirements. But if the easement says it's for a public street, that is where we interpreted the end of the street right-of-way to be.
Okay, because I see in one diagram.
I know, there's an error in the one that's on the screen. Everything should be shifted down because the easement for street purposes actually is next to the
Okay, that was my question, because I did see the
one diagram, it's correct, and the other, it's shifted up.
Yes.
Yeah.
The one, it looks like purple and blue shading. Okay. Yeah, because I was just trying to get that straight.
Yep.
Okay, I gotcha. So then we're all on the same page as far as that.
So, Madam Chair,
Mr. Owen.
following up on that, as a result of that analysis, you produced 2 photographs in the staff report right before the tax map. There's 2 diagrams that show red areas and green areas superimposed over the fence itself. And I'm wondering if that's something we could put up on the screen. There we go. That's the one. Okay, so these red areas, are you saying that those are based on calculations you made using not the incorrect line, but the correct line for where the street easement ends? Is that right?
I'll actually go ahead and answer that one since I'm the one that made the photographs. I would say that these are approximations based on the correct graphic that showed 8 feet and 6 feet for the vision triangle, and then 25 feet, and then everything beyond that.
Okay.
So I didn't go out and measure which picket it ends at, but this is representing those 3 levels.
Got it. Thank you. So the green areas are, roughly speaking, allowed by right. Is that right?
Correct.
And the applicant is seeking this use permit for the red areas?
Correct.
Okay. Thank you.
Any other questions of staff or the applicant?
Oh, actually, I do have one other question for staff.
Okay, go ahead.
Based on a question you got from me, you asked DES for whether or not there's any bicycle policy on the 11th Street or Monroe. And my understanding of what they said, and the applicant's been provided, and it's now part of the record what they said, but my understanding is that they basically said that there's no special bicycle facilities that they've built on either street, that Monroe Street has been identified as a convenient street by policy for bicyclists to use in part because of its connectivity, and that there's future plans for using 12th Street South as a bicycle friendly route, and that there's no specific designation or plans for designation for 11th Street either way. Am I fairly summarizing the response?
I would say that's a pretty fair summarization of it.
Thank you.
Other questions?
No questions, comments.
Go.
It seems to me that the most offending part of this is the brick column. And so I'm looking at what could be done in that area of the brick column, because, I'm willing to hear what my colleagues think about the fence height, but it is more permeable in terms of visibility. But it's the pier that obviously right at the corner is an issue. That said, if the pier goes, it may be more practical to take the corner off, if that's, as one of the, as the speaker said. So that's what I'm trying to figure out, is if there is, the safety concern with visibility at this corner is certainly exacerbated by the brick pier.
Madam Chair?
Mr. Malik.
I'm concerned about the safety element too. Just what the speaker was saying about that. And there is a reason for this, for the triangle. And there is something that's definitely non-see-through. You can't see through the column, and that's right dab in the middle of this, area that's definitely within the triangle. So that's my concern. As I ride bikes, I drive, and I know how important it is for visibility. And that's what concerns me. And I understand the cost that's gone into this, and it seems to me, though, that, I think safety takes precedent. It's an unfortunate situation all around, just the fact that it's here. But that's what I'm thinking about here and what concerns me. So I'm leaning toward not granting it just on account of the safety issues.
Madam Chair?
Mr. Owen.
I've visited the site twice now, and part of the reason I asked about bicycles is my observation was that when you are looking through the fence at a right angle, it's pretty permeable, almost like it's not there. But if you're looking along the fence, at a certain angle, it might as well be a brick wall, because you can't see, because the iron bars line up with each other. And so the practical effect of this is to decrease the distance that vehicles or pedestrians or bicyclists have before they start to, for the first time, see each other as they're looking through the 6 foot high fence. So I appreciate that the fence is not, in some mathematical sense, not as bad as an actual brick wall, but it also definitely obscures some of the sight lines that the county has established as a safe zone. So my inclination would, I'm afraid, be to just ask that it comply as a safety matter. A single post somewhere, iron post or here or there, or a decorative, element here or there is one thing, but this is a regular, series of individual posts that do create a visual obstruction. So I'll join any motion that reduces it, and my own inclination would be to not grant a use permit for any part of the area in the 25-foot triangle.
So just to clarify, those of you who are inclined not to approve this, of which I am not one, you would not just lower the column or remove it, you would lower a good bit of the fencing as well on both streets. I can't support that, but go ahead.
Madam Chair, it seems, I mean, it seems that the deferral that we just had, the result of it was merely to clarify
The triangle.
the triangle, and that there's been no discussion of options from the applicant's standpoint, given the direction that the board feels that something needs to be done. You know, what would the applicant be willing to do? We have not had that conversation, which we often do. So just to simply deny at this point might be premature, because we often do go through a process of, you know, seeing what options are, you know, what remedies are possible, and keeping the case alive. So we haven't done that, and I certainly would be open to that. In terms of, you know, there's a range of possibilities here, which is exact compliance versus something
Okay,
that.
got it.
So if the applicant were interested in something like that, you know, I would make a motion to defer this matter.
Well,
But I'm not sure how.
hold off just a moment. Mr. Lehman, could you come back up? I frankly, based on the discussion I've heard, have no clue as to where we're going. I mean, I think there's some support for your existing fence, and I think there's some opposition.
Yeah.
So in light of what Ms. Malice just said, can you provide the board with some of your thoughts about mitigation?
Yeah, I guess we would have to go that way. I certainly don't want people riding around the fence thinking it's unsafe, even though I've never had anybody in the whole 9 months it's been up ever say a word to me. You know, I've even asked them on the street, hey, do you have a problem with this fence as opposed to anything? And just, you know, in general, nobody has ever said a word. And I find it very unfortunate that I have a homeowners association that won't come over to my door and knock on the door and say, hey, Henry, listen, you're going through this stuff. You have this post here, and we're kind of have a little issue with that, you know? Never a word, okay? Never a word. So I would have to have a little time to come up with a design, okay? If we're going to lower the column or remove the column, because I've got about $60-something thousand tied up in this fence. And if I put an ugly part right there, then it's going to be ugly forever. I have a couple of options. Either fix this or take the fence down and go to Home Depot and Lowe's and put up a nice wooden fence. If that make everybody happy, that'll be fine. And I'll make it just like it is. But I'm telling you this, out in front of my yard, I got a lot of other things that I have to do. The open area that's in front right now has 97 spots where dogs urinate on it. And they're not coming from the homeowners, you know. Some, not all, most of them is just around the area. There's no dog runs out there, and I'm trying to keep everything pushed back over there. And I don't care what they do. That's my property, but, hey, they're just dogs, okay? But, yes, I think what we need to do is just kind of settle down, let me figure out with my designer about the fence and see what we can do about just lowering the column. Now, my idea, now if I'm going to lower the column, and we're going to make it, is to put a cap back on top, okay, at whatever we decide, okay, and then come up with a beautiful decorative post, say a 3 by 3, right in the center, and then go out from there. That may be a solution.
Well, let me suggest that you've heard all the comments and you've seen all the diagrams, and this one is particularly telling because it's pretty clear.
This one?
Myself, I would leave it just as it is. And actually, the staff agrees with that because they're recommending approval.
Okay.
So I feel like I'm in good company.
Okay.
But apparently that isn't going to fly. So given that, then I would suggest that keeping this diagram in mind, that perhaps we have a deferral till, say, December, which would give you plenty of time, and then whatever you proposed, we could consider. The staff's going to have to see all of your proposals and advertise it appropriately, et cetera. So it's not something that can happen in the next couple of weeks.
Yes, it's a very costly endeavor to go do stuff.
And I understand that. I'm totally sympathetic.
Yeah.
But that's my suggestion. Yes, Mr. Smith.
I agree with you. I would have supported the staff's proposal. I thought months ago there was nothing wrong with it. I've seen this corner. I used to ride my bike down that street when I lived on South 8th Street all the time when the old post office was on the corner and before all of that was developed. And
Well, is everybody against the street, the fence being?
I think it's a wonderful fence. I have no problem with it whatsoever. I would take a look at, as the chair has advised, and try not to disfigure what you've done. Try not to, don't go to Lowe's. Don't do that, because what you have is really nice.
I know, and I built this fence for Arlington.
It does accent the corner very well.
And if you look around everywhere in Arlington, this fence is nothing other like it anywhere around here.
And in South Arlington, that area, it was a good development, and your fence sets that corner off, I think, in a nice way. I understand the sightline issues. I understand the zoning ordinance. And that's why we're here, to provide some relief from a strict application of that ordinance. For the benefit of the neighbors, the staff support it as it is. So keep that in mind when Mr. Lehman talks to you about what he might do to garner 3 of the 5 votes up here, because I think he has 2 right now, as it is. So I wouldn't try to burden him too greatly, and I would, if I were you, try to make it as preserve its integrity as it is as much as possible, because destroying it, I think, would be unsightly and create something worse than what we have, and be distracting, and thus be a safety issue, because right now it blends in wonderfully, and it isn't distracting. So those are my views on it, Madam Chair.
Thank you. Am I correct in my assumption that if there was a motion for approval, it would fail before we go any further? I'm making that assumption based on comments I've heard.
I think so.
Okay. Then I would entertain a motion for deferral.
Madam Chair, I
Mr.
move
Smith.
that we defer V-11296-17-UP1 to the December meeting of the Board of Zoning Appeals, to allow the applicant and those interested parties an opportunity to look at some adjustments that might be made to
The design.
the design.
Second.
Moved by Mr. Smith, seconded by Ms. Malice for a deferral to December BZA. All those in favor?
Aye.
Thank you. See you in December. Next case, please.
Next case is case number V-11314-17-UP1. It's a use permit request by Marissa Solis, the owner, to continue a setback of 7 feet to the wall from the South Walter Reed Drive right-of-way instead of 25 feet is required, and to permit a setback of 3.07 to the eve instead of 19.5 feet as required, regarding a new 2-story addition, including portions done by right, over existing walls on a corner lot in the R6 zoning district on the premise known as 3402 17th Street South. Staff recommends that the board adopt the attached proposed resolution granting the use permit request to permit a setback of 7 feet to the wall from the South Walter Reed Drive right-of-way instead of 25 feet as required, and to permit a setback of 3.07 feet to the eve instead of 19 feet as required, with the conditions noted. Note that there's supplemental material for this case that came in after the application packet was assembled and printed.
Thank you. Questions for staff?
Madam Chair.
Mr. Owen.
Mr. Rissy, could you just briefly describe the 2 supplemental items that we received?
Yes, we have one letter from Rebecca Ballo, who is a preservation planner here for the county. The question was asked whether an archaeologist should be hired to look at any possible digging in the area, and she, in essence, has answered that for a number of reasons it may not be necessary, and if they find anything, they're welcome to keep it, and if they have questions, they can contact the Arlington Historical Society. The second item is a letter of support from Laura Lopez, the neighbor located at 1746 South Walter Reed Drive.
Thank you.
Thank you. Can we hear from the applicant, please?
My name is Marissa Solis, the owner of the property. We just wanted to make an addition to give my daughter and I more space with our house. We would not be enlarging the footprint at all. We just wanted to expand the kitchen on top of the concrete open porch that we have right now.
Thank you. Questions for the applicant? No speakers?
Madam Chair?
Mr. Smith.
If you accept a motion, I'd move that the Board of Zoning Appeals adopt the attached resolution granting the use permit in V-11314-17-UP1, subject to the conditions that are listed in the staff report.
Second.
Moved by Mr. Smith, seconded by Mr. Owen for approval. All those in favor? Aye. Thank you.
Thank you.
Madam Chair?
Mr. Owen.
In the next two items, I'm recusing myself because of various relationships to applicants or neighbors. And so I'll be voting present in V-11315-17-UP1 and V-11316-17-UP1 and not otherwise participating.
Thank you. Call the next case, please.
Case number V-11315-17-UP-1 is a use permit request by Robert Martinson, the owner, to permit a setback of 15.1 feet to the front addition, 14.4 feet to the eave, from the Washington Boulevard right-of-way instead of 25 feet to the front addition, 21 feet to the eave as required, and 15.1 feet to the front addition, 14.4 feet to the eave, from the North Taylor right-of-way instead of 25 feet to the front addition, 21 feet to the eave as required, regarding a new front addition on a corner lot in the R5 zoning district on a premise known as 4301 Washington Boulevard. Staff recommends that the board adopt the attached proposed resolution granting the use permit request to permit a setback of 15.1 feet to the front addition, 14.4 feet to the eave from the Washington Boulevard right-of-way instead of 25 feet from the front addition, 21 feet to the eave as required, and 15.1 feet to the front addition, 14.4 feet to the eave from the North Taylor right-of-way instead of 25 feet to the front addition, 21 feet to the eave as required with conditions. Additionally, please note that there's supplemental material for this case that came in after the application packet was assembled and printed.
Thank you. Questions for the staff?
Yes, Madam Chair, porch-like structure.
If that's a question, I'll go ahead and answer that.
Well, it's either it's the main roof. Does that make this part of the main, make this basically part of the building itself as opposed to a porch?
That is, by our definition, the way we are viewing this proposal. Correct.
So another term for porch-like would just be building?
Yes.
Building. And you're going to use the rules for the building as opposed to the rules for a porch?
Correct.
Okay. Applicant or agent?
Yeah, Doug Voss. I'm Robert's agent for tonight. And if there's any questions that I can answer, I'd be more than happy to do so.
Okay. Any questions for Mr. Voss, who's the agent for the applicant? besides who put that big giant thing in the front yard? No questions?
Madam Chair,
Yes,
if there's no other speakers, I'd like to make a motion.
please.
All right, so in case V1131517 UP1, I'd move that the Board of Zoning Appeals adopt the attached proposed resolution granting the use permit. In that case, subject to the conditions listed on the resolution.
Second.
Moved by Mr. Melnick and seconded by Mr. Smith for approval. All those in favor? Aye.
Thank you.
One. There's one present. Absent, present. Okay. Next case, please.
Case number V-11316-17-UP-1 is a use permit request by Nicholas Pateo and Donna Frangoli Pateo, the owners, to continue a side setback of 4.9 feet to the wall with 4.5 feet to the eave, the same as existing, instead of 8 feet to the wall and 5 feet to the eave as required, regarding a new one-story rear addition and other by right alterations in the R6 zoning district, the premise known as 825 Jefferson Street. Staff recommends that the board adopt the attached resolution granting the use permit with conditions.
Questions for staff? Applicant, please.
Sean Bueller, Bennett Frank McCarthy Architects, agent for the owner. Thank you, staff, for the effort on that report. We don't take any issue with any of the report or any of the conditions, and I'm happy to answer any questions. Also want to just reiterate that the neighbor immediately adjacent to this project is supportive of the project as indicated by the letter in the report, and the owners did reach out to all of the adjacent property owners and secured their support as well.
Could I ask that you fill out a speaker slip as the agent and just give it to us for the record?
Sure.
Thank you. Any questions?
I just have a comment. I don't know, did you write the letter of justification?
Yeah, I believe I did.
So we look at compatibility, and the comment was that it was compatible with current market preferences. We usually look at compatibility of what's there, but it was I just turn a phrase.
That comment is meant to address the notion that the existing house is undersized for the site and has several smallish spaces, and the intent of the project is to open up the floor plan to make the house more desirable and more viable in the long term rather than become a tear down, which is what we're trying to avoid.
So it's really, you're talking about internally.
Well, the more desirable we make the interior of the house, the more likely the exterior, which is compatible with the scale of the existing neighborhood, will remain, as opposed to being replaced by a much larger house, which we consider to be less compatible. So there are market conditions that drive that, and while they put internal pressures on the house, I understand that your concern are external. So they're not unrelated.
Understood.
Thank you. Other questions? Thank you.
Madam Chair.
Mr. Smith.
Ms. Malice has really tried to help you out, and you did say the right thing at one point, but then you went back to the market. But it's really staying compatible with the neighborhood is really what you achieved by your design. Therefore, I'd move that the Board of Zoning Appeals adopt the attached resolution granting the use permit in V-11316-17-UP1, subject to the conditions that are listed in the staff report.
Second.
Moved by Mr. Smith, seconded by Ms. Malice for approval. All those in favor? Aye. Present? One present. Thank you.
Thank you.
Next case, please.
Case number V-11317-17-VA-1 is a variance request by Joshua Lee Harris and Meredith Ann Harris, the owners, to permit a maximum building footprint coverage with a front porch of 28.9% instead of 28% as required, regarding a new screen porch, stairs, and landing in the R10 zoning district on the premise known as 3100 North Rochester Street. Staff recommends that the board adopt the attached resolution denying the variance request. An alternative resolution has been provided should the board decide to grant the variance.
Am I to understand that the reason for the denial is 0.9% coverage?
The reason for the request is 0.9%.
Okay. Questions for staff? Applicant, please.
Hi, good evening. I have a landscaping plan.
State your name for the record.
My name's Meredith Harris, and so I'm the resident. And I have a landscaping plan to show you all, if I could.
These 5 identical pages? Is that what you
Yes,
handed us?
yes, it is. So as you can see, the home that's in the picture is not our current home. It was a new build. We bought it already completed, not knowing that we were at 99.9% of our maximum mean footprint of the building. So we have since had neighbors on both sides expand their homes. And I'd like to note that we picked the house. We moved from Old Town. We picked the house because of the yard. We loved the yard for our kids, and we set a minimum of 10,000 square feet that we wanted because we felt like the smaller lots that we saw these huge houses on just didn't have the yard. And we bought the home with the idea that we would get a screened-in porch eventually. The existing porch, which has been recommended to be screened in, isn't correctly supported to be the deck is not correctly supported to be a screened-in porch. We would have to tear that down anyway. With builders that I've had come by, they've also said it's not to scale with the house. It's going to look like a toy screened-in porch based on the scale of the house. What I've given you is we plan on putting a dry well in to increase the drainage. We've had some problems in the back of the property where there have been some drainage problems, and we would just want to alleviate that for everyone, for everyone around us.
Questions for the applicant? So the staff report says that the deck could be enclosed, but your testimony is that it's not properly built to actually be an enclosed porch.
Correct. We've had a few builders come by to give us estimates. Some have said, yes, we could potentially keep your porch. Others have said, no, we didn't put those bases in. We don't know how deep the concrete goes. We don't know, how deep the wood platforms go. We wouldn't be comfortable because we don't want to be liable in case that collapses. So I trust a builder telling me that than someone saying, oh yeah, well that'll probably work.
Right. Any other questions?
Just a comment. Madam Chair, we've had other cases where the builder has maxed out the coverage and has left the homeowner in this spot. And I think if there's anything we're going to do, it has to be legislative to handle this, because we've had these kinds of cases before where there's no justification for a variance just because the builder maxed out the footprint.
Mr. Melnick?
Yeah, I'm in agreement. I think it'd be a terrible precedent to grant this variance. obviously builders are trying to maximize their profit, and, for anyone, hopefully, I can't recall if you said you were actually misled, but it seems like, if some research was done, into the zoning requirements, that this could be determined, but I just think it'd be a terrible precedent. And plus, it seems very clear from the staff report that, that at least the conditions of the unreasonably restricting the utilization of the property or hardship, it's very strong arguments that those requirements haven't been met for a variance. And plus, I don't know how much investigation you've done about the different options, perhaps some structure in the rear, like, I don't know, a gazebo or something like that that's not connected to the main structure. There's lots of decorative things out there like that, but I just think, first of all, I clearly don't think the criteria are met, but also, I'd encourage you to investigate other options, maybe even work with staff to see what's feasible. But I feel very strongly about that.
Madam Chair.
Mr. Owen.
We've had previous occasions where we know that the developer, where we've been told very specifically that the developer or the builder said to the purchaser, I'm leaving this up to you so that you can build this back area, right? We've had situations where a real estate agent has said, look at this lovely house and all you have to do is build in the back of it and it'll meet all your criteria. And then they come to us and we've said, sorry, it doesn't comply with the law. So I think it's, it's really infuriating if you've been led to believe by these people you think are experts that you can do something and then it turns out it actually isn't allowed. And so I don't want you to think that we don't lack any sympathy for people who are in that position. But unfortunately, as government officials, we have to work within the law. And so that's the challenge that we face.
Other comments? Motion?
Madam Chair,
Ms. Miles.
I move that the Board of Zoning Appeals adopt the attached proposed resolution denying the variance V11317-17-VA-1.
Second.
Moved by Ms. Malice, seconded by Mr. Owen for denial. All those in favor?
Aye.
Aye. Thank you. Sorry. Next case, please. Yes.
Sorry, last one for the night. I also need to recuse myself in this case.
Got it. Thank you. Mr. Rissy.
Yes, case number V-11318-17-UP-2 is a use permit request by Greg and Mary Mullen to permit a setback of 24.9 feet to the North Oxford Street right-of-way to the wall of the left side addition instead of 25 feet as required, and to permit a setback of 24 feet to the North Oxford Street right-of-way to the wall of the right side addition instead of 25 feet as required, and to permit a setback of 24 feet from the 6th Street North right-of-way instead of 25 feet as required, regarding two-story left and right side additions, as well as a second-story addition with new roof and eaves on a corner lot in the R6 zoning district on a premise known as 538 North Oxford. Staff recommends that the board adopt the proposed resolution granting the use permit to permit a setback of 24.9 feet from the North Oxford Street right-of-way to the wall of the left side addition instead of 25 feet as required, and to permit a setback of 24 feet from the North Oxford Street right-of-way to the wall and 24 feet from the North Oxford Street right-of-way to the wall of the right side addition instead of 25 feet as required, and to permit a setback of 24 feet from the 6th Street North right-of-way instead of 25 feet as required, with the conditions recommended by staff.
Just for my information, why is it that sometimes you have to read the whole thing a second time, and other times you just say, I'm going for the shorter option.
I am happy to go with an abbreviated option.
Okay, it just confused me that there seems to be, it's sort of random what happens. Thank you. Now then, any questions for staff that aren't picky? Hearing none. Applicant?
Good evening. My name is Greg Mullen. I'm one of the owners. I guess just real quick, a procedural piece here is that from the standpoint of how we submitted the use permit request, we asked for 24 feet on both additions, but the staff wrote it as 24.9 on the left side and 24 on the right. We're going to be okay on the 24.9, but had we not been, I'd be back here a fourth time, so that would not have been fun. So anyways, questions?
Any questions of the applicant? Ms. Malice?
Just to clarify, your discrepancy makes it small. You need 24 feet, not 24 feet?
We were going to, just to keep it simple, we were going to ask for 24 on both sides.
But
Even though we don't need, we really need the 24 more on the right side than the left. Yeah, so the last wall check on the left side was 25.2, but that didn't include our stone veneers, so we built in extra margin for that. So that's our 24.9. But we were just going to ask for 20. We asked for 24 on both sides, but they wrote in 24.9 on the left.
Live with 24.9.
The building is existing,
I hope so.
right?
Yeah, the house is built.
It's
We're
there.
trying to finish it.
It's
so.
not what's in the picture.
So.
It's not even close to what's in the picture. I don't know where that came from.
There you go.
That's what really is there.
There's our hotel.
Yeah.
Can you,
Ms. Mouse, go ahead.
Can you tell me where the Harristons live? Harristeins? Where?
They live across the street.
That would be across Oxford Street?
They are, in that picture, they're the house that's in front of the red like SUV.
Okay.
And then the other folks that wrote were 2 doors down.
And what about your next door neighbors?
The ones directly to the right.
Both sides.
So we have one in the back and one on the right.
You have one left facing, or back, I guess you'd call that back.
Yeah.
Do you have any input from them?
So they had, on our use permit last year, they sent an email saying it was fine. I reached out to them again this time, but I didn't get a reply, and they're not here, so I assume they're okay with it. The one to the right, so we've talked to them before, but I don't have any contact info for them, so I didn't reach out to them. And we're asking for inches, so if you're asking for like 10 feet, okay, but we're just asking for a few inches. So.
Any other questions for the applicant?
Madam Chair?
Ms. Malice?
I'd like to make a motion that the Board of Zoning Appeals adopt the attached resolution approving use permit V11318-17-UP-1 as recommended by staff and subject to the conditions listed in the resolution. And I'll just note it's proposed resolution, but that's the one I'm talking about.
Good.
Second.
Moved by Ms. Malice, seconded by Mr. Smith for approval. All those in favor? Aye.
Aye.
Thank you very much.
Thank you.
Thank you. Next case, please.
Next case is case number V-11319-17-UP-1, which is a use permit request by Thomas H. Lloyd and Elaine M. Lloyd, the owners, to permit a left side setback of 7.1 feet instead of 10 feet to the wall as required, and 5.9 feet to the wall with 4.9 feet to the eave instead of 8 feet to the wall, 5 feet to the eave as required, and an aggregate side yard setback of 11.9 feet instead of 18 feet as required, regarding a new rear addition in the R5 zoning district on the premise known as 1244 North Taylor Street. Staff recommends that the board adopt the attached proposed resolution granting the use permit request with the conditions noted.
Questions for staff?
Madam Chair, do we have speakers on this item?
Yes,
Do we have a lot of them?
that depends. I have the 2 applicants and their agent, and they're not all having 20 minutes as checked, but in theory, we have 6 if everybody speaks.
Madam Chair, I do have some questions for staff. In our packet, there was a letter or an email or a memo from a neighbor who appeared to be opposed to the project, but I don't think I saw the address of the neighbor. Do you know the address of the neighbor whose opposition was in our packet?
I have 2 speakers who are opposed.
Madam Chair,
you asking Mr. Owen about Tom and Elaine Lloyd?
No,
Someone else.
that's the applicants.
For the applicants.
Yes, I believe the neighbor was located at 1248 North Taylor. The reason that the name is not on the letter is because that was a letter that was given to staff when the neighbor came in to talk about the project. If you notice, it's really more a list of questions than a typical letter of opposition. So that's why it's unnamed.
Nonetheless, helpful to know where it came from. Thank you. How wide is the applicant's parcel?
$40 feet.
And so in order to have a buildable lot, 50 feet is required, right?
Correct.
So the only reason why a variance isn't required to build on this lot is because they're keeping the existing structure. Is that right?
Well, yes, because the existing house was built in 1939 is the year we have.
Right. Okay. And do you know, I'm sorry, I think you just answered my question, which is when was the lot created?
We don't have a date on the lot, but we know the original house was built in 1939, so we're assuming the lot was created before the house and therefore predating 1950.
Thank you.
Other questions? Ms. Malice, you look like you're looking for a question.
I was just reading the comment about the neighbor at 1248 in the letter, saying that he spoke with the resident renters who said they didn't have any problem, but they are the ones that came in and asked questions.
No, it was not the renters who came in. It would have been the owner of the property.
Came in.
Correct.
I see. Thank you. The owner opposes. Okay.
Okay. Now,
Okay.
we have a slip from each of the applicants and a slip from Skylar doing a repeat performance. So is everyone going to speak? In which case you...
We just had them fill out the papers in case you did ask for them to speak. In Fairfax, they ask for anyone who speaks to swear in, so I just didn't know if that's the same formality or not. So.
You go for it.
Okay. Are we ready?
Yes, indeed.
Okay, sorry, thank you.
The clock is ticking.
Yes. I understand the staff generated this report. I stand by it. I agree with it. I just recently, actually, as of Monday morning, got the opposition letter, so I did have a chance to look at it. I did speak with the homeowners about it. I do have a lot of experience personally with permitting and expediting and design, so I'm familiar with a lot of the questions that the homeowner presented. If staff or the board does have questions pertaining to the letter of opposition, I'm happy to answer any questions pertaining to that. But essentially, it's just a typical Arlington neighborhood. There's a lot of non-conforming structures in the neighborhood. I wish there was a more recent picture up there because if you're looking at this picture, the neighbor to the left actually has what you would consider almost the exact same structure where we have a newer structure. So it looks like a new single-family home. And as you can see, the two houses to the left of that are also two-story structures that are existing. I believe those are still the way they appear. And then to the right of the house is another house that's existing. That's more of a two-story, 1.5. That existing house is about roughly 12 feet higher than the house in question, Mr. Tom and Elaine's home. And so it just seems a little strange that they can only be the only ones in the whole row there who can't have a second-story addition, but that's, I guess, a different topic. But essentially, they want to do what everyone else has been doing in the neighborhood. They want to go up above the house, which they can do by right, and they do want to extend out the back because what they have square footage-wise just won't accommodate modern necessities for this area. We do have it staggered in toward the rear, going from the right side. So there is a little bit less intrusiveness, not a great deal, but about a foot less as it staggers in going down the right side of the house. So it doesn't go flushed end to end like a lot of the other other houses do. So even though we are extending in line with the existing sides of the home that are non-conforming, the right side, we are kind of trying to create less of an intrusive encroachment than what already currently exists. Other than that, I really don't have too much more to add, so I'd free to allot my time to you for any questions you may have.
Questions for the applicants or agent? No? Okay.
Is there anything in particular in the list of, I don't know, I think maybe we shouldn't call it a letter of opposition, but the list of grievances or whatever we're going to call it?
I mean, I could address a few things. I mean, everything I think is addressable in my opinion. Just some of the things I see that are called out just looking at the list. I know there was a concern about disturbance. I believe he's probably calculating the floors themselves. I did see the discrepancy in coverage, and I immediately jumped on it because I know once you go over 2,500 square feet, it generates where you have to have a grading plan and creates a whole lot more cost and time and everything. So I make a personal effort to try to stay away from grading plans and stay under the 2,500 square feet. So we did have the surveyor calculated, even worst case scenario where we have to upgrade the water pipe. They're still coming up with I believe it's 2386 or something like that. And there were places we could have cut corners to kind of reduce, and that's a heavy number. It could even be a little less. Height, I see it as concern about height. Again, the only thing I can say is every other house on the left side is twice the size of their house currently, including the neighbor to the right. Eyeballing it is about 12 feet or so higher than theirs. I know he had concerns about light and air. I did go over there because I wanted to refresh myself before I came over here, just to make sure what I was saying was accurate. I will say, I don't know if staff took pictures or not, recent pictures, but I'll say there seems to be a lot of trees going around the house, and I don't see much light coming through currently from the shrubs and trees that are currently standing there, so I don't know how much more light will be taken up by this structure going up next to it. Yeah, I don't see anything else that's really, they asked if we had drawings for allotted parking. There is a current kind of weird shared driveway that the neighbor shares with the neighbor to the left. Very strange. It's weird. It shares the property line, and it's not very big. I think they kind of have to flip a coin to see who parks there. But I will note that the house to the right has no driveway that I saw. I could be wrong, but there's no on-site parking at that address either.
So you're not planning to change the parking?
I mean, if they can stay under the square footage of land disturbance, I think maybe they would like to. But at the moment, I don't think there's an immediate plan to, no.
What about water runoff?
Sorry?
I think one of the concerns listed was water runoff.
I saw that. Again, when I looked at the site, I started looking around, taking pictures. I will say the grade appears to be fairly level. I am not a geotechnical engineer, so I won't play one here today. But I will say that, again, if it's under the 2,500, usually it's a pretty safe indication. I would assume if DES, Department of Environmental Services, sees anything, of course, they'll red flag it and we'll address it accordingly. But at the moment, I don't see a concern for runoff. But, again, I'm not a geotechnical engineer, so.
I have a question for staff at the appropriate moment.
Any other questions for the applicant?
Clarification. So the person that came in with the list of questions is the neighbor at 1248 on the corner.
Yes, I believe. If you're staring at the house to the right, yes, on the corner. Yeah.
And to the left, it's 1240. I don't know if we have, I'm trying to figure out if we have.
Oh, you're looking for the support from, I was looking for that too. It's on the very top. I missed it myself, actually.
Thank you.
No problem.
I got it.
Yeah, that doesn't look like a zero.
Yeah.
Got it.
I did the same thing myself.
Got it.
Okay, are we good? Okay, thanks for the moment.
Thank you.
You want to ask your question now, Mr. Owen, or what?
Thank you. So the applicant just said that 1240, the house to the left, has recently been improved and seems to be of a similar scale to what they're proposing. But I didn't notice that house listed in the staff report as a comparable. And I'm just wondering if that's because they obeyed all their by right setbacks, or because you felt like you had enough other examples, or what. But I just wanted to see what staff's view was of the comparison between this house and the house to its left.
Well, Madam Chair, there is a mention in the
Did I overlook it?
the next page. He says from the Board of
Oh, yeah.
There's a description. They talk about they got a use permit in.
Oh, you're right. I skipped over that because I was looking at the.
He had so neatly put all the others.
Yeah.
In that and left the 4 to 12.
Just goes to show you how visual graphic elements catch the eye. All right.
Okay, let's have the speakers, please. Stan Dobson.
Thank you for giving me a chance to talk. My name is Stan Dobson. I am the owner of the house next door. And I thought that I submitted another letter, but unfortunately it was rather late, and I'm not sure. That was less of a question type thing and more of an opinion. Anyway, like I said, I'm the owner of this house that will, I think, be seriously impacted by having this house rise that high. And there's one thing, I realize there may only be a 12-foot difference between the proposed house and ours, but we're on the corner, we have plenty of air and light on the other sides, we're not encroaching, it doesn't overpower anybody. One other thing is that there's a great diversity on that street. There have been no tear downs and only, I think, one major rebuild of the 36 houses, and 2/3 of those houses are owner occupied. And I think that we start letting, as the gentleman said, that this house is going to be a duplicate of the one that's not shown in there. If that starts happening, we'll have a street just like the one I sent you the aerial view of in Falls Church, where they're all, it looks like Levittown or Bowie, and I don't think that's what we want in Arlington. Other than that, I have a lot of other comments, but I'm told that this is not a debate here, so.
Thank you. Eric Dobson.
Good evening. My name is Eric Dobson. I live on North Utah Street, not adjacent to this property, a few blocks away. I don't have a financial interest in this property, although my dad said at some point I might, but right now I don't. I want to thank all of you for your service to Arlington. Ms. Malice, I miss our time on the Planning Commission every once in a while. We know in Arlington we do a lot of stuff. We love to study stuff. We love to think stuff. We spend a lot of time looking at building heights. We spend a lot of time looking at coverage. We spend a lot of time looking at side yard setbacks. We look at a lot of time about a garage that's in the back of your house, whether you get additional coverage for that or you get less coverage. We love studying stuff. And part of the reason we study stuff is we want to protect our community. And part of the protecting our community is our zoning rules, which are there to protect the safety, health, and welfare of our community. But we also have a plague in Arlington, and that's called McMansions. You can go through any part of North Arlington, and South Arlington is starting to have its share as well of homes that just don't fit into the neighborhood. You have people that are purchasing properties, spending a lot of money to purchase the properties, and then deciding, I want to put a house on this lot that I like, regardless of what the zoning codes are and what the requirements are. And on this, I'm actually, without getting into all the technical details, I'm actually more concerned about the precedent. I disagree with what their attorney said. This neighborhood is actually extremely stable. As my father said, the 1200 block and 1300 block of Taylor Street, there are 36 homes. Only 4 of them have had major additions. None of them have been tear downs. If you expand that to include North Utah Street and North Stewart Street, it's 102 homes. And of the 102 homes, only 16 of them have either been torn down or major expansions. It's an extremely stable neighborhood. Well,
Sum up.
I will sum up. I'm just concerned about the precedent. All these lots are substandard. So once we start making an exception on one, then others are going to come forward too, and the developers are going to come into the neighborhood and change that community. Thank you very much.
Thank you. Comments, questions?
I've got a,
Madam Chair,
I have a question. Oh, go ahead.
I defer to my colleague.
Comment about
Yes.
substandard lots. Is that an issue in this case?
It was the question that Peter was getting at earlier, that the width is not typical, but since the age of the structure predates the zoning, it's not an issue in this case.
Well,
Mr. Owen?
Well,
it's a factor, all right? They don't need a variance because of an unbuildable lot.
correct.
But oftentimes the substandard lots create a general limitation on what's reasonable. Ms. Malice, or Madam Chair, I don't want to.
No, I was.
You done?
I'm done.
Okay, Madam Chair.
Yes, sir.
So it's customary, I think, for the BZA in this kind of situation where the next door neighbor has come to us identifying concerns, that we allocate some time for the neighbor and the applicant to chat. If we think there's any hope of getting adjustments to the application that might lead to better consolation for the applicant. And so, better, a resolution that will allow both parties to come behind it. And so I can't tell whether or not this is a situation like that. I don't know if the objection of the neighbor is to anything remotely like what's being proposed, or if there are specific elements that could be changed that to the application that might make it a lot less objectionable from the neighbor's standpoint. And so I'm trying to figure out how we could get clarification on that.
The applicant referenced a letter that evidently was sent late, and you're not in receipt of it yet.
Well, it's entirely possible. I'm in receipt of it.
But it's...
I did not miss it on purpose. I did not miss it on purpose. If I'm fully believe he sent it in, it's in my inbox somewhere.
That letter might help clarify Mr. Owen's question in terms of are there specific issues?
He may have a copy of it as I see him going through his papers.
Well,
Madam Chair,
Mr. Smith?
I understand Mr. Dobson the younger's position and Mr. Dobson the elder's position, obviously. I also obviously understand the homeowners. And when you're considering that you're just going kind of straight up, as you say, it's hard to talk about encroachments to the side because they already exist. And the only thing constant is change that we experience in life. And so these neighborhoods will change. The house that was built in the 30s is no longer suitable for today. Yes, it could be occupied as a dwelling, but in a realistic sense, it's not, as we heard earlier, speaker say, it's not in conformance with the market. It's not market compatibility. These old homes, and so they're going to change. There are going to be improvements. We hear young families come in constantly talking about the need to provide for their families and additional space. And then we hear from the seniors who want to age in place and therefore reduce the need to go upstairs to have a bathroom on the first floor. And all of those changes are because we're accommodating the future. And these neighborhoods with these old homes are going to change also. There are limits to how far they can go, and and sometimes, that adage, be careful what you wish for, because the by right option sometimes is worse. We've had many cases where the neighbors have come in and said, well, it's going to overshadow my house, but it's only 28 feet, let's say. Their by right option is 35 feet. but slightly narrower. So you know, sometimes you have to pick your poison when embracing the future. And in this case, I understand the homeowner's desire to remodel, increase the size of the house and keeping it in conformance with today. And therefore, and we've seen so many just like this. Therefore, I don't have a problem with what they're asking, and and that's kind of where I am on it. And I just say that to kind of put in perspective for the neighbor what I see as a trend in Arlington.
Other comments?
I'll make a motion.
Mr. Melnick.
In case V1131917 UP1, I'd like to move that the Board of Zoning Appeals adopt the attached proposed resolution granting the use permit with the conditions as stated in the proposal.
Second.
Madam Chair.
It's been moved by Mr. Melnick and seconded by Mr. Smith for approval. Mr. Owen.
Mr. Dobson, the elder, has presented us with a copy of the letter, so we're passing it around. We only have one, but I'll presume that will go on the record. I feel like this is close enough to other situations where we have deferred for a month for additional neighbor discussion that I would be personally willing to vote for a deferral for a month for those discussions to occur, even though I'm a little bit skeptical that there are specific things that the neighbor has identified that, you know, it's not, and a lot of them we have something like there's a berm or there's a water runoff issue or there's a tree or there's a shading or, you know, something specific to be worked on. And here it's not currently that way. But sometimes if the neighbor understands that some kind of approval is going to be granted, then that sharpens the mind and leads to greater level of compromise. I can't tell whether or not there are 3 votes for a deferral, but I'll just throw out there that if there were, I would be one of them.
You could make an alternate motion.
All right. I move that, how do I do this? The parliamentarians get mad at me when I say substitute motion because there's crazy things that happen when you do substitute. But I move that we not vote on the immediate prior motion and instead vote on a motion to defer.
I would second that.
Okay, then. We're going to first vote on a motion to defer, and to what end?
That was going to be, Madam Chair, that was going to be my question. And I would want to hear from Mr. Dobson as to whether he thinks that would be of any benefit to him.
Would you come up, please?
Because it's not going to change my view, actually.
Yep. My expectation would be, can we do a month? Is that time to advertise? Do we have time to advertise for November?
The advertisement deadline has not been reached. It is Monday to get it to the paper.
Oh, they would only have a few days.
Correct.
So we need a December deferral. All right,
Could
so
you
that's
respond to
what we're
that,
talking
Mr.
about.
Dobson? Okay, the question is, if we defer to December, customarily we do that so that the people who can get together and work on some possible compromises? Is it your opinion that that's even feasible?
No, I thought about this, and I realized that things could be worse if you do it by right. And I guess that's where I was thinking that we should go, but there's not going to be any change on my opinion. The gentleman talked about all the bushes and trees in between the 2 houses. They're just bushes. They're not a 2-story addition. And the 2-story addition will definitely be more of an impact than a few shrubs around the side of the house as far as circulation and light. But no reason to defer.
Okay. Thank you for your candor.
Madam Chair,
Mr. Owen.
I move to withdraw my immediate previous motion.
Thank you. We're back to the main motion, which is for approval.
I just, for clarity, I presume I think I had to make my very last thing by unanimous consent.
Okay, you're asking unanimous consent.
Withdraw my immediate previous motion.
Okay, you have unanimous consent. Now then, all those in favor of the motion to approve? Aye. Opposed? Thank you. Next case, please.
Case number V-11320-17-UP-1 is a use permit request by Than N. Lam and Jeffrey Sign, the owners, to permit a setback of 21 feet to the wall instead of 25 feet as required regarding a new two-story rear addition and by right deck in the R6 zoning district on a premise known as 6245 27th Street North. Staff recommends that the board adopt the attached proposed resolution granting the use permit request with the conditions noted in the staff report.
Questions for the staff? Applicant, please.
Good evening. You're almost done. Just a few more cases. So I'm Jeffrey Sine, co-owner with Tan Lam of the home in question. We've been living there for about 21 years now, and we're seeking to do something that someone else addressed earlier. We're trying to open up the interior space, make it a little bit more spacious and comfortable. And curiously, one of the things we discussed is hoping that this modification is going to make it attractive enough so if in the future there's a new buyer, they won't tear it down and rebuild. Seriously. So we have reached out to all 6 of our neighbors on the side. This is a corner lot in the back. On the other side of Quantico, the 2 neighbors that would have visual sight of the new structure addition, and then the 2 on the opposite corner from our house. And everybody is given unequivocal support. One in the back, she calls 2 of our trees volunteer trees. And one of them is a relatively small but growing maple that planted itself. So we've agreed we'll take out those volunteer trees. I've never heard the term volunteer tree before, but so be it. If you will, sorry, I only have 3. I've never been to one of these hearings, but these just, maybe you can share them. These just show the consequences if we don't get the approval, what we'll have to do. So basically, it's just a little 4x4 push out instead of, so we're 21 feet here, and we want to extend that wall another 4 feet. So we make that back room more open. Right now, it's kind of just a single-story reading room, if you will. And we're going to make that into our dining room. The kitchen's going to be pushed out. And so in order to not have that nook in the new dining room, we seek permission to use the space going 4 foot further along the 21-foot setback wall, another 4 feet to square it off. That's essentially what we're doing. And, of course, we're going to build a second-floor addition on that, which many in the neighborhood have done, to create more space upstairs as well, so that 4x4 out would sort of rise up there. That's it.
Questions for the applicant? Thank you.
Madam Chair?
Mr. Smith.
We usually don't see even 21 feet on these corner lots. So given that you have 21 feet, I'd move that the Board of Zoning Appeals approve the use permit in V-11320-17-UP1, subject to the conditions listed in the staff report.
Second.
Moved by Mr. Smith, seconded by Mr. Owen for approval. All those in favor?
Aye.
Aye.
Thank you very much.
Enjoy. Next case, please.
Case number V-11321-17-VA1 is a variance request by Michael Shipley, the owner, to allow an addition to a non-conforming building in an RA6-15 zoning district and to continue a non-conforming setback of 3 feet to a deck instead of 5 feet as required regarding a new rear deck in the RA 615 zoning district on a premise known as 1733 12th Street North. Staff recommends that the board adopt the attached resolution approving the variance request with the conditions noted in the staff report.
Madam Chair?
Mr. Owen.
Yes, I have a question about this for staff about something that I didn't understand in the staff report. In the final full paragraph on page 3 of the staff report, analyzing the question, would the granting of variance alleviate a hardship due to a physical condition relating to the property or improvements thereon which existed upon the effective date of the zoning ordinance? And the final paragraph says, the granting of the variance would therefore alleviate a hardship created by the adoption of the zoning ordinance, which placed the property into a zoning district not typically consistent with nor intended for single-family dwellings. This legislative action rendered the property non-conforming to an extent that any addition requires a variance or heavily modifying the existing building. Are you saying, it appears that you're saying that any zoning change that renders a property non-conforming creates a hardship, and that struck me as an unusual thing for staff to say, so I thought I would seek clarification.
Okay, that is not what we're attempting to say there, so I apologize if that's how it came off. What we're saying is, in this specific case, because of the zoning district that they were placed in, the fact that they exist where they do on the lot creates a situation where they do not have the ability to do any addition or enlargement, which other similar properties, other single-family dwellings in other single-family zoning districts have the ability to do. So it is specific to the placement of the property, which was limited by that legislative action.
That sounds to me like it would apply to any situation.
No, it only applies to single-family dwellings outside of residence districts. So because this is a single-family dwelling in an RA district, it's treated differently than the vast majority of improvements to single-family homes that we see. It's because it's in an RA that it's different.
But if it were an R6 district, how would the situation be different?
An addition or a change could be made if it was compliant with the current regulations.
But an R6 district requires 60 feet, and it only has 57.
If it was platted before and the lot was created before the regulation existed and a house was built there, an addition could be made as long as the addition met the current requirements. In this case, no addition can be made, no enlargement can be made at all via a use permit.
So like the last one that we were seeing with the 40-foot thing, that was existing non-conforming, but they could come in with a mere use permit.
Exactly.
Because they were building onto
Or if they weren't adding to the back, they could do it by right if they just went straight up.
And so because this happens to be a zoning district where use permits are not, we don't have the power to grant
Option
use
for
permits.
single-family dwellings.
When the board does that, and there's not a use permit option available, you're saying that in all of those situations that there's a variance qualifying hardship.
Yes.
I have to admit that I'm still a little skeptical of that rationale, because the use permit option for BZAs is a fairly recent creation. And
it would have all been variances then.
Yeah.
Prior to that. This would have been, this is one that not captured by the use permit.
Yeah, and I'm aware that we used to give variances in situations that nowadays tend to go the use permit route. But I still feel like, the statute is pretty specific, due to a physical condition relating to the property or improvements thereon.
So the building was built in its current location before the ordinance existed. So that's the physical condition. It's the location of the structure on the lot.
I see. So this is similar to the argument that I was making a couple of months ago with the I want to call them duplexes, but we don't say that under the zoning ordinance. But there was one in South Arlington, just north of Columbia Pike, on that funky little neighborhood. And I was for that one saying, well, you've got this very old house that's farther back than all your neighbors, and so building a front addition is related to the fact that you have this prehistoric house.
Where it is.
Right. And so you're making that argument now for granting a variance.
Really as we could have.
Okay. I think I understand that a little better. I thought another question, but I've lost it, so I'll
Let's
pause for
proceed, please, with the applicant. Oh,
I
sorry,
had a
Mr.
question.
Melnick.
Yeah, for that, for me, like, I'm an attorney, and I know that legislative bodies, they're deemed to, intend what they're doing. And I was struck by that too, where it says, it placed the property in a zoning district not typically consistent or intended for single-family dwellings, because they must have known that there were single-family dwellings in there. And it seems like that reading is really nullifying, what it's saying, the provision about, basically the whole structure needs to comply. So, for me, I have a hard time with that too, where it's just deemed, just because the house is in the zoning district and a single family, it's deemed to have a hardship. Because then, I have a hard time with that too. That's what I'm saying. I would think the county board would intend, why didn't they carve out single family buildings? That's what I'm wondering. So that's, I just had a hardship too.
You want to talk about it?
Follow up, is this different than the structure on, next to the Heidelberg? That's also in a...
It's an RA, I believe that's an RA district also.
So an RA district.
Which has virtually no by right. That's also the size and the shape of that lot is problematic.
Is staff making the same argument for that?
That's a variance also.
It was a variance request.
It's different.
Well, that project has had many iterations. So initially, it was an addition to the existing structure, which we were supportive of, because the existing structure is where it is, and it's where it's been for many years. When it changed and it's a brand new structure, we were not supportive, because then you have opportunities to change things and be at least more compliant.
But would you say there was a hardship created by the zoning district?
So I guess it's a different way of saying, I think the hardship is created by the fact that the structure was built before these rules existed. So the structure is in a location where these rules that we have now didn't apply when it was constructed. And to me, the location of the structure is the hardship. What's added on is the fact that in the RA districts, there's fewer options for either by right changes or changes that could be approved via a lower, for lack of a better word, standard through the use permit process.
So I guess part of what confuses me is that the RA 615 district actually appears to have many or all of the rights to build single-family homes that's available in R6, plus a lot of additional ones. For example, multiple kinds of two-family dwellings, as well as multiple family and townhouse. So if you're taking, and that was the other question. I'm sorry, I didn't even seek recognition before launching in, Madam Chair. But my other question was, has this ever had any other zoning other than RA 818 and RA 615?
Yes.
What other zoning has it had?
It appears to have been zoned RA 716 in 1942 and Residence A in 1938.
What was that last?
Residence A?
Resident A.
There were A districts and B districts, I believe, in the first version.
And yet the house is 1924, so we don't get our usual 1950 cutoff. Okay. But it was never R6 or R5, because those zoning districts didn't exist at the time it was moved to RA 818, probably.
I'm sure they did.
Oh.
It was RA, or Residence District A, initially.
Is Residence District A a single-family district, or was that a multifamily district?
I
Combination.
believe that was a general single-family.
Might have included a couple of different types. We only had two types of residential districts. I don't remember if that included, for example, single and two-family.
Right.
I just don't know.
But anyway, my point is that it looks like anything you can do in an R6 in terms of the setbacks and the, leaving aside what you're dealing with as a, based on the existing structure, which I guess is what you're hinging this on. But the general regulations that apply to single-family home construction in RA 615 seem very similar to the basic regulations for single-family homes that apply in R6.
Except that no additions or enlargements can be made via use permit.
Via use permit.
Right.
And so.
Or by right.
Right. But prior to the Virginia legislature's creation of the use permit process, BZA use permit process, they were identical in terms of single-family home.
There still would have been a by right option, I don't believe.
Because of the size of the lot.
Because of where it's located, because of where the building is located.
Okay.
Can we move on? Yes. Applicant.
Michael Shipley, I'm the homeowner, and I just wanted to say thank you to the board and the staff for all the time and diligence for this. While I understand this is more of a legal legislative matter, I would simply add, and maybe this photo wasn't available because it is the rear of the house, but I can provide this. The back of the property is on a sloping hill, and that would be a true value. It's not like I could theoretically turn it into a patio or any other form. And when I first purchased the property, while I was excited to learn that it is zoned multifamily as well, I did not realize that this would require, coming before the board to build a deck. So this is all very new to me. And I have achieved and provided the neighboring homeowners' approval letter.
Thank you. Questions for the applicant?
So there is actually another property that abuts two sides of yours where there's, I guess, an apartment building right now and the parking lot?
The parking lot, yeah.
Have you talked to anyone there about your proposal?
I've not. I frankly wouldn't know who to reach out to unless I put a letter in every mailbox, but...
Do you happen to know if it's a condo or an apartment building?
I believe it's a condominium originally that is now offering apartments, I believe.
Okay. Well, that makes me think of a question for staff. Madam Chair.
Yes, Mr. Owen.
So our official mailings would have gone a letter to every condo owner, right?
Did.
They
certainly went out, and if it is condos, it went to every owner.
Went to 10
on
owners
that
or whatever it was in there.
Parcel.
Yep. Okay. Thank you.
Without interrupting, I can add that, or with interrupting.
Just keep it moving. That's right. That's fine.
There are the yellow signs everywhere. I've seen those as well. So.
Right.
Yep.
Thank you. Other questions for the applicant?
Madam Chair.
Mr. Owen.
I'm, as you might have been able to tell, really super uncomfortable with the staff's analysis on the hardship side of this. But I do think that this is a good one for the unreasonable use prong of variances. So on that basis, I'm perfectly happy to vote in favor of the variance. But I just wanted to say that I wouldn't be as inclined if we had to apply the hardship analysis.
Would you care to make a motion?
I don't until I hear from my colleagues.
Again, we entered a realm of legal discussion that is not appropriate to delve into in the time that we have sitting here, and so we can't really get all the answers to how this works, but, to the extent that we do allow relief for topo issues as a hardship, as considered a hardship and a variance, we could certainly rely on that, and I would be happy to do that. And the lawyers can question my reasoning, but that's where I'm going.
For the applicant is you can win even if we disagree on why, as long as we all have our own reason for saying yes.
I'm happy to make a motion.
Please.
I move that the Board of Zoning Appeals adopt the attached proposed resolution approving variance V11321-17-VA-1.
Madam Chair, I'll second that, except in the staff report, when you look at page 5, proposed resolution, it's really talking about the case we just had.
Wrong resolution.
The deck case. But I presume that.
So I can read the variance request?
Yeah.
As in the subject line, to allow an addition to non-conforming building in an RA 615 zoning district and to continue non-conforming setbacks of 3 foot to a deck instead of 5 feet as required regarding new rear deck in an RA 16 zoning district premises known as 1733 12th Street North, but we don't have conditions.
Correct.
And the conditions would be, would there be the conditions on other variances?
Well, let's see what he's trying to do here.
Let me find another.
It's kind of an addition he'll be putting on here.
While you're sorting that out, I will eventually at some point move to strike the 5th whereas clause, because that's the one that endorses the hardship analysis of the staff, which I don't agree with.
Oh.
So we can strike all of their analysis, and because we don't really.
If the condos sue, it's better for the homeowner that we have a stated basis.
Which whereas clause?
So the one at the very bottom of page 5.
And that's right, Ms. Malice's motion was based on the topographic, the hardship bearing on the topographic issues with respect to the property, which I also agree with.
Yep. So I'll throw my vote around to make sure that the applicant gets a majority somehow. But if we keep the hardship analysis in, then I'll vote against the motion.
So, but we don't have a resolution that references the hardship.
Okay, we need somebody to arbitrate and move it on.
Well, I think, so here's the problem. We don't have our paperwork in order. And the most, I don't know if we have enough time tonight to get it all in order. It probably, if it were me, but I'm a stickler, as you might have been able to tell tonight, if I were the homeowner, I would want to wait a month to make sure that I had a legally sound action from the BZA.
I want to know what the conditions are that I'm voting on, because
I have to withdraw the attached
not
resolution.
a use permit request, and therefore the conditions might be a little bit different.
Right.
And to address Mr. Owen's concern, I would withdraw my second and move to defer to have a staff report that does properly reflect.
And I had an outstanding concern also that it didn't have, didn't realize how inapplicable I didn't look at the heading. I looked at the conditions and saw that there was not a built over or enclosed limitation there too. So that can be remedied as well.
The resolution, and I saw this is not right.
So I think the easiest thing to do would be to defer to November. And certainly Monday would be plenty of time for you guys to have a revised proposed resolution ready, right? Yes?
Did you have another comment, Stephen?
I was just going to say the three conditions that are listed on page 6 of the staff report are applicable. If you wanted to add over a not to be built over, it's certainly available to you.
It's a little uncomfortable to just do it on the fly.
I just would like to ask a question.
Sure.
So you have a concern about the staff analysis about hardship, but then there was a motion made that referenced a different hardship, being topography. And so the whereas clause doesn't speak to a particular hardship, it just says a hardship due to a physical condition. So why wouldn't that be able to apply to either?
I think in order for you to do the best job in getting a new resolution, that we should poll ourselves and find out who thinks on what basis and use whatever has the majority.
I'm getting confused with the paperwork here. Where are you reading, what page are you reading what you just read?
The bottom of page 5. The last whereas clause generally references a variance that would alleviate a hardship due to a physical condition.
So you're suggesting that be, because you understand the previous part whereases are all wrong.
Not necessarily.
No.
Because there's still variance whereases.
28.9% versus 28%?
That's the first
That
one.
paragraph is wrong, but the other whereases might not be wrong. But I would say one of them is inapplicable, although...
Well, and Madam Chair, the staff analysis is not a part of the resolution.
Exactly.
Well...
in litigation, though, the whole report would be in, and and it would all be looked at and ensured, but...
As well as a copy of the hearing.
What my hardship is...
I agree with... I hear what you're saying. I think my view is that I don't think there is any version of hardship that applies to this site. And so I can't vote for the hardship prong. I can vote for the reasonableness prong and get to a variance, but not the hardship prong.
Okay, can I suggest that because nobody can agree on anything, that we have a motion to defer to November, straighten it out by Monday, properly advertise it, and we'll apologize profusely to you. But I think in the long run, if you have a nice clean report and a clean motion, you're better off.
Madam Chair.
I don't sense anything except an approval ultimately. Mr. Owen.
I think it might help everyone if we, respectfully, if we had a sense of your views on the basis by which you might be inclined to grant a variance. Are you troubled by finding a physical hardship or not? And depending on whether you are or would want to use the reasonableness prong, that might help the drafting process.
I perfectly accept. I actually believe that legislatively it was a problem because of the way when the house existed in whatever zoning category it was and where it is now. But I understand that there may be some disagreement with that. I definitely agree with the topographical issue. And I'd like to see him be able to very modestly make changes to his house. And I want that to go forward.
I think that probably should do it.
Mr. Owen, you're not willing to indicate a hardship due to topography?
Correct.
Well, in the end, he can vote no.
But there's 3 votes now for the whereas clause that's in
Mr.
there.
Melnick.
So I'm in agreement with Mr. Owen on this. I don't see any hardship either. So I'd be in agreement that the whereas being referenced about hardship ought to be stricken.
But
okay.
So we're probably headed to a 3-2 vote on the basis, which is fine because the applicant still gets their variance and the 3 of you can agree on the rationale.
Okay.
I'm just confused on what my rationale is. You're saying that topography is not, what is the rationale then? If it's
That
not
was yours. Don't,
okay.
just because he doesn't agree with you, you don't have to change.
But what is
let's not argue it now.
What's the alternative? If it's not, it's just reasonable in this?
Correct. There's the state legislature changed the variance law 3 years ago and said even when there's no hardship, there's another way to grant variances. And under that version,
I'm fine with that.
I'm okay with it.
I'm fine.
Okay, can we have a motion, please?
I move that, Madam Chair, I move that we defer this item to the November BZA meeting.
Second.
Moved it, Mr. Owen, seconded by Mr. Melnick, to defer to November for all the reasons we have all discussed. All those in favor?
Aye.
Aye. Thank you.
Well, let me vote no on the deferral because I just heard that we got to 3-2, and it would have passed tonight, but that's okay.
It was
Have a thing to pass.
3 opposed.
We didn't have conditions and all that other stuff.
Right. I presumed that we were not going to see it tonight.
Yeah.
And it's 4-1 deferred, right?
The motion to defer passed. Moving on.
Sorry about that.
Please call the case.
Case number V-11322-17-UP-1 is a use permit request by Polly Hall and Matthew Hall, owners, to permit a front setback of 14.1 feet to the front porch, 13.6 feet to the front porch eave instead of 21 feet to the porch, 19.5 feet to the porch eave as required regarding the addition of a new side porch on a corner lot in an R6 zoning district, premise known as 3200 6th Street North. Staff recommends that the board adopt the attached proposed resolution granting the use permit request with conditions noted.
Thank you. Questions for staff? Mr. Owen.
So I had asked you guys about the fact that we often have conditions for porches that say the porch shall not be subsequently built over or enclosed, but I didn't see that condition in this particular application, and I was wondering if it was being singled out, and if so, why?
It is not being singled out. I made the assumption that since the current ordinance does not allow for by right development over porches, that would suffice for that possibility. If the board chooses to further that by making it a condition, it is certainly the board's opportunity to do so.
I guess historically, was there a reason why we always had that condition in? Was this just belt and suspenders, or is this notice to that we would not consider building over the porch?
It certainly wasn't the latter, because we've routinely subsequently permitted building over, but you have to come back. So I had understood it to be a belt and suspenders notice issue.
Belt and suspenders is good with me, to make it clear to the homeowner that.
Okay. Skylar, one more time.
Thank you for the board, to the board for the opportunity. I promise this is the last time you'll see me for quite a few months.
State your name for the record, please.
Aaron's.
Thank you.
Just to piggyback off my previous hearing, I am not a lawyer. I do design and consulting and a lot of permitting, so I just wanted to clarify that for the record. This is pretty straightforward. I don't know if you remember at the hearing on Monday, I was doing a house that was doing the wraparound porch on the opposite corner of this same exact street, about 5 houses down. So this request is very similar to that. What I'm quickly finding out in this neighborhood is that none of the houses are conforming to the front setback. If you go further down the street, there's some that are like 5 feet away from the property line, which is pretty remarkable. The homeowner at the last moment had indicated to me that there was a board member interested in support from the church, since that was actually the property being most affected. We did forward that email to Mr. Reese just a little bit ago, so I know he probably hasn't received it. Apologize. It was a last-minute request, and they were able to get permission. So we have forwarded that to Mr. Reese. A trustee and the pastor of the church both endorsed this project from what I read on the email. As far as some of the other neighbors, it was quite ironic. I heard from my owner from Monday that they were hard to reach neighbors in that neighborhood, and ironically, when I spoke to the homeowner of this property, I'd asked her, hey, we only have 4 signatures here, and she said, same thing, it's very difficult to reach people in that neighborhood. And so that was the reason why there was just a few signatures there. But again, the property most affected is directly across the street, and again, we did send that to Mr. Reese. With that being said, and just to clarify, I believe only the front porch on the true front of the house is the porch in question. I believe the porch on the side is by right, so just to clarify that as well. With that, I leave it to you for any questions you may have.
Questions? Mr. Owen.
I'm going to propose shortly that there be an additional condition that the proposed addition shall not be built over or expanded without a further action by the BZA. Is that a problem for you in any way?
No, sir, that's fine. And we're just specifically saying the front porch, the one in question for the BZA, not the side one, correct? I just want to make sure they're differentiated.
Proposed front addition?
Yeah, well, they're technically, because it's a corner lot, there's two fronts, and there are two porches being built. So I am just specifically make sure you request that you identify that porch. Correct, yes. Apologize.
Is there, so that's the one now being proposed as opposed to one that already exists?
Or the one on the side that's being proposed in the drawing so that you can see the full proposal is by right.
Porch. I see. So
it's in a corner lot, so that's why I keep saying front, because by definition of
on
front.
the 6th Street side?
Yeah.
Other questions? We have one speaker, Joan Arsenault.
Good evening. My name is Joan Arsenault. I live on Ivy Street in the 500 block of Ivy Street, which is just around the corner from this house. And I'm coming here to tell you why I'm supporting it. Ashton Heights in our particular area is an old area. We live really close to the streets. We have small lots. We have mostly small houses. But the porches enable us to sit and talk with one another when people walk by. And I know my neighbors a whole lot better because they're there. We have one house that was built recently, and it's 25 feet back, I think. And they're isolated from, because they can't even use the front porch, so they basically have no access to the neighbors. And it's a wonderful neighborhood, but everything new isn't better, and I claim that what we have with the porches, especially the porches, I mean, the porches make it. I mean, there's a few houses without the porches, and I think they should all put porches on so they can sit, they too can sit, have a glass of wine, whatever, and chat with the people when they go by. And it happens. I mean, it seems strange, but it really does happen. But in our case, because we're in that porch is actually pretty closer to the streets than a lot of the new ones. But because we're there, can we see each other? And so I think this is an urban area. We're not suburban. We're not out here on acre lots. I have a 47 feet, 8 inches, I think, something like that, wide lot. I mean, we're really close. But most of my land is in the back, so if I want to do something by myself, I can do it. When I want to talk to my neighbors, we're all out in the front. And I know they're much better for that. Thank you.
You're welcome. Thank you for staying so long.
Madam Chair.
Mr. Smith.
Now, Ms. Arsenault, I think, were you here last, was it Monday or last
Yes, I was here Monday for his other house.
Okay, yeah.
Yes, I do look familiar, maybe.
I recall, I just couldn't remember where it was, and you spoke about porches then, and that's wonderful. And for the client of Mr. Ahearns, he just comes with a lot of cases all the time.
Yeah.
So don't be put off by our
This
comments.
was sort of coincidental, because I've been talking to those people on 5th Street.
And I believe in porches too. And Madam Chair, I'd like to make a motion
Please.
that we approve the use permit in V-11322-17-UP1, subject to the conditions listed in the staff report.
Second.
Madam Chair?
Oh, wait a minute.
Including condition that the porch not be built over or enlarged.
Mr. Owen, is that all right?
So my understanding is that the motion includes a condition that says the applicant agrees that the porch on the 6th Street side shall not be built over or enclosed.
That's correct.
All right. I support the motion.
Moved and seconded for approval. All those in favor?
Aye.
Thank you. That's the last case. We have minutes from September 20th.
Madam Chair?
Mr. Owen.
I noted that the vote for the deferral was a little more lopsided than reality. So I think it was actually a 4-0 vote and not a 40-0 vote.
Okay. Can we move it with that addition?
Madam Chair, I just, this October meeting, Monday, was not a special meeting. It was a carryover meeting. Is that right?
Recess. I would call it a recess.
I don't think a special meeting has a different connotation.
It might.
This might have been a special meeting?
Yeah, so the code actually does speak to carryover.
Oh.
There's like terms in the code.
This wasn't a carryover.
Well, I don't know. I didn't check.
All right, well,
So I would say, since you point out the issue, I would move that we pile this on to the deferred minutes that we're going to consider at the November meeting.
yep, we can call it a special carryover,
But since there's a you've reminded me that there's a statutory term we should use, and I don't know which one it is, and I'd feel more comfortable if we just waited.
we should use whatever term is right.
Right,
So let's defer these to
the November meeting.
the November meeting. Okay.
I move that we adjourn.
Madam Chair, was there an action to defer the minutes?
Action to defer. We didn't vote on
I move
that.
to defer.
Second.
Aye.
Okay.
I move to adjourn.
Second.
Aye.